Okay, well, welcome back to the Board of Psychology meeting, the second day of a three-day meeting. Just to help us keep our focus, I will mention the mission statement again. The Board of Psychology protects consumers of psychological services by licensing psychologists, regulating the practice of psychology, and supporting the evolution of the profession. Again, when we get to public comment, which we're about to do after we take roll, please don't mention the name of any specific licensee or any pending matter. But that being said, Ms. Burns, could you please take roll?
We're going to do the roll in the way of this so we can pan it.
Okay.
So, take
This is LA. We got to do it based on what the camera looks like, right?
Tape.
Here.
Archie.
Here.
Akwebadu.
Here.
Phillips.
Here.
Fu.
Here, and I don't have a mic, so I'm going to project myself today, apparently.
Here, we have an extra one.
Oh, excellent.
I'll adjust it in a second.
Oh.
Horn.
Here.
Bernal.
Here.
Thanks, Jackie.
Thank you very much. Okay, so item number 12 on our agenda is public comment for items not on the agenda. I'll just read my little admonition here. Before I invite speakers to come forward, I would ask individuals making comments to not discuss the specifics, including names as to pending complaints, pending license applications, or pending disciplinary actions that may come before the board. Such decisions are considered ex parte communications, as they could provide information to the board members that is outside of the record in violation of the Administrative Procedures Act. Board staff is available to speak to you individually and answer your questions outside of the hearing of board members. And I will remind the board members that public comment is a time for people to put comments on the record that we may decide to agendize, but we cannot address because they are not on our agenda for today. Okay, that being said, is there anyone that would like to make public comment? Seeing none, I guess I didn't need to read that long preamble. Why don't we move to item number 15 on the agenda, since we've already done items, let me flip this thing. Since we've already done the minutes and the budget report, the next up would be the outreach and education report. Ms. Bernal. Good morning.
Good morning. Sorry, I was opening something up. I have the combined, what page?
47.
Thanks. Oh, good morning, everyone. Just quick update here on our website. Social media, everything is pretty much the same. We're looking at the results here where we're seeing normal hits along the way. Ms. Burns, is there anything else that we need to add aside?
I think we would just want to talk about our website user
website,
friendliness.
I'm sorry.
Yeah. The user friendliness
website. I'm
focus
sorry.
groups. No
Sorry.
worries. Do you want me to
Thank you.
kick it off for you?
No,
Okay.
I can kick it off. We held website focus groups in Northern and Southern California. Southern California was February.
25th.
Northern was March. We extended invites to our psychologists, students, and consumer groups. We were able to collect a good pool of candidates that gave us great insight on how we can make our website more user-friendly. We are taking that feedback and working with staff to work on revising the website, and we plan on seeing those changes in 2020. Does that sound about right? Okay.
So, and I think speaking from experience, and Antoinette and I were at both focus groups, it was a great way to engage with licensees and applicants and consumers on these issues. So I think Antoinette can very much attest to, we had quite a bit of engagement with both groups, and that was a really good thing. So.
Ms. Sorg, is there anything you'd like to add? Okay. So, okay. So then we're on to, am I on the right? Because I feel a little lost right now. We're on then the website, or just social media, correct?
It's all information.
15A. Okay. Let me see. So website hits, as you could see, everything is within normal activity. And I do, sorry, this is just, this combined thing is not working for me. Our newsletter is Ms. Sorry, can you help me? Like, just really I'm having a hard time here.
Sure, no problem. Included in your packet, on the combined packet, it's 47 to, I believe, 49. It has the top 5 hits for our webpage, and then the other pages that the board identified as pages we want to track hits over time on a quarterly basis, so you can see what our quarterly statistics are for that, and then we're happy to answer any questions you might have.
Okay, thank you. Page, going on to 15C. Oh, this is terrible. You see our attached newsletter. We've got our summer journal that's going out in July. I believe all our new articles have been submitted, and we're ready to move forward.
Yeah, since we're out this week for the board meeting, I anticipate having early next week all the content for the newsletter, and then I'll be editing that, compiling it, sending it to Dr. Phillips for review, and then it goes to Ms. Marks for legal review, and then it goes to publications for putting it all together.
Thank you. Oh, this is terrible. Let me just get through our journal here. This is not... Okay, agenda item 15D in terms of our outreach activities. I understand both Dr. Phillips and Ms. Sorick were able to attend the ASPPB that took place last month. Would you all like to give us a little bit of information on that? Thank you.
Ms. Sorick and I were both invited speakers at the ASPPB Mid-Year Conference, which was held in Santa Fe, New Mexico. Although the conference was so busy and engaging that you didn't really realize that you were in Santa Fe until you actually walked outside the hotel, which wasn't very often. But it was a really wonderful opportunity to interact with other administrators and other board members and board chairs regarding a variety of different topics. I spoke on the conflict between being a licensed board member versus being a guild member versus being a licensed psychologist, and how those three things come into action. I think the most fascinating thing for me about the ASPPB convention was talking to people that have completely different setups, different experiences. The registrar for Prince Edward Island was there, who has a total of 20 psychologists under his watch. So it was kind of fascinating to see how different things, how different people did different things. I was very grateful to be from California, where we have such a capable board staff, and where the constitution of our board is such that it is not dominated by professional associations, although professional associations have wonderful purposes for psychologists. It's not the same as being a consumer protection agency. There are some states where the board is made up predominantly of licensed psychologists, like 8 out of 9, for instance. And the way they're chosen is the professional association gives a list to the governor, and then the governor picks from that list. So it's a very different frame of mind where, and I'm not sure I don't know the particulars of how those boards conduct themselves, but it's a very different frame of mind where you allow the industry, so to speak, to dominate the Consumer Protection Board, although it seems to be very common in Washington these days. So with that in mind, did you have anything you wanted to add?
I spoke on board member orientation training, and it was great because we had just had Dr. Harbsheets and Dr. Tate, their orientation training. So hope you don't mind, Dr. Tate, but I did use your picture in my slideshow. Yeah. Because we're so proud of you. But it was interesting to hear how some of the other administrators on board, new board members, and I'm sure staff can vouch that I was shooting emails throughout the conference, things that came up from other states. And as I was sharing with Dr. Horn the other day, my first ASPBB meeting, one of the Canadian provinces included education history in their license lookup, and that I thought was a fantastic idea. I brought it to the board. It became part of our sunset bill. So I think there's some really fantastic and worthwhile ideas that we can get from ASPBB, what works for us, what works for other jurisdictions. So it's just great to have the ongoing dialogue and communication, and I hope we can get approval to go more often because I think it's a really worthwhile opportunity for us.
And I think people were glad that California was in the House because we do have a very different experience. We have the largest board. We have the most number of licensees. I think we have the most board staff of any state. So sharing with them different procedures we do and the way we think about things was equally stimulating for other states. So I'm very appreciative of the cooperation we got from department, agency, and the governor's office in order for us to be able to attend the ASPPB convention. For instance, we started talking, one of the topics that came up was social media and the use of social media by board members and how board members sometimes inadvertently talk about things on their social media that relate to things that are happening internal to the board and how problematic that is. So it's going to probably change how we do board member orientation from this point forward. I personally am a antediluvian, so I do not have any social media, I'm happy to say. But all those things being said, I think it was a really wonderful opportunity, and it was a very meaningful experience. Yeah.
Thank you. And Ms. Sarek, could you please give us a little bit of information, maybe if you know, on the CPA Division 2 meeting that took place in Los Angeles? Or hi.
Good morning, board. Licensing unit, we have sent our licensing and breach coordinator, Ms. Maisong, to attend and provided an update regarding some information of the board at the CPA Division 2 conference. So staff found that information is valuable and relevant because it's talking about supervisors' information, and we reminded, or actually let them know that licensing committee will be seeking input regarding the informational videos, and so we solicit input if any of them can attend in our future licensing meeting scheduled in September. Yeah, so I think it was a great experience for us to be part of the conference.
Oh, thank you.
Absolutely.
And now for agenda item 15E, I'm excited to share our DCA brochure, Professional Therapy Never Includes Sexual Behavior update. I understand that all boards have now reviewed it, approved it. Yay, it's sent to Department of Consumer Affairs to include all changes. And I'm sorry, when will it be printed out? Do we know?
I just got a mock-up, and I'm working on some stock images with the publications unit. So the So the professional therapy never includes sex brochure will become the therapy never includes sexual behavior brochure, and that should be done within the next 3 months. So that's
Oh,
the
wow.
hope.
That's exciting, and that's a great way to end my report. Any questions? Thank you.
Any public comment? Thank you very much, Ms. Bernal. Didn't mean to spring that on you. We came up with it a little bit faster than we were expecting. We are next going to move to the licensing report. We've skipped around in the agenda a little bit because we've had more time in these mornings to conduct business than we'd originally anticipated. And given that fact, I'd like to get as much of it as done as possible so that on Friday we might have a shorter day. And people might be able to head back. I know what it's like to go to the airport at 3 o'clock in the afternoon. So the licensing, which number's the licensing committee? 20. Okay, so item number 20. Ms. Chung.
Good morning again. The licensing report can be found on your combined PDF, page 72, in case you need the information. As I mentioned earlier, we have some outreach activity regarding CPA Division 2, and provided on the report is our statistics regarding license and registrations data, workload application data, and the examination data. If the board have any questions, please feel free to ask.
Board members, any comment or questions?
I have a question. When y'all went and presented at Division 2, did you get any volunteers to help with the videos, informational videos?
We have some inquiries, but we haven't have any names that or like a RSVP yet to state that they will be attending, but there's some interest regarding that.
Okay.
Anyone else? Any public comment? Well, that was a remarkably short.
I can extend it with a question.
Okay, please do.
Ms. Chung, I'm curious to hear what were the reactions related to the board's decision related to the EPPP Part 2 at that outreach meeting in February?
I didn't, because Ms. Song was attending, so I didn't hear any strange comments per se. So I think they're just appreciative of the board that's able to provide an update so that they know what to do or what the board is going to do pending on any information the board needs to in order to make another decision when that time comes. Absolutely.
Great. Well, hearing no other comments or questions and no public comment, thank you very much, Ms. Chung.
Thank you.
Okay, we are rolling now. We're doing continuing ed? Okay. Continuing education and renewals report. Ms. McCochran.
Good morning, board. So for the continuing education, the audits for January to June 2017 just concluded on April 2nd. So I haven't completed all the reviews yet, and once I do, I'll be able to report that to you by the next board meeting. I did want to highlight that over 60% of our licensed psychologists and psychological assistants are now renewing online, so that's great. And also, from the strategic plan meeting back in December, it was decided that we would do board member audits, and that will start January 1st, 2019. So after January 1st, 2019, licensed members will be audited. Right now I'm on 2017, so you guys still have a ways to go, but that's all. Is there any questions regarding? Yes.
So I'm looking at the percent failed in between January and June 2017, page 82. And I see 0%. Is that because you haven't finished going through them
Correct.
yet? So we
Yeah.
don't know. Okay. Thanks.
It's not really zero, no. By the next board meeting, I'll have the accurate numbers for you guys.
So I have a question. When you, the 36%, I think it was, who failed, now you will re-audit them next year, correct?
Their next renewal
Their
cycle.
next renewal. So can you tell me again what that number of those people who are being re-audited, what is the pass rate? So it's the second time for them.
For the second time, I don't have, it's around like 80, 90%
That pass?
that passes.
Okay. All right, good.
I usually put that in the statistics, but I didn't this time since I wasn't complete, so I'm sorry about that.
That's okay. No
But yeah, it's
problem.
usually around 80 or 90%.
So it's encouraging.
Yeah.
Okay, thanks.
I don't know that I find that encouraging. Given that they've been audited and they're told that they're going to get audited the next time. Yeah, you
That
understand what I'm
makes sense.
saying.
I do
And actually,
understand.
I think it's a little higher than that. If I recall correctly from prior reports, it's been like 20 or 30%.
Oh, who are not passing?
Who are not passing.
And looking at
Even though
the-
they've been told
Oh.
they're going to get audited
The
next
second
licensing
time.
cycle.
I mean, it really, even the fact that 36% don't pass the first time, that's pretty surprising.
I often think our licensees have gotten maybe used to the idea that there's a potential for an audit out there, and since they haven't been audited before, they may become a little lackadaisical about complying with the requirement. So I'm sure it catches their attention when they do get audited and gets caught. But one would hope in a profession like ours, when people certify under penalty of perjury
Yeah.
that they've done something, that they've actually done it.
Yeah, I wonder, maybe you can help us, how many do you think fall into the category of sending in their license renewal prior to the renewal date and then quickly get in the rest of their CE hours before the renewal date?
It's very rare. From the audits that I've seen, usually they have it all completed by the time that they renew. The number one reason people fail is being short hours, so it's a lot of miscalculations and organizational issues with some psychologists.
We are looking into this in the in licensing
Licensing,
committee
right.
and just kind of the whole process and everything, so.
Thanks.
One of the things that's commonly come up, and correct me if I'm wrong, Ms. McCochran, but sometimes people send in CE certificates, they haven't really looked to see whether they were approved for CE hours. So for instance, I do a lot of work in chemical dependency and behavioral addictions. A lot of the continuing education that's offered is not for psychologists, so it's not certified. Or they'll have a certificate that doesn't even indicate who the agency is. So there are sometimes, I think, people are making innocent mistakes, but they need to be more careful about making sure that they've got approved providers for their CE hours. So hopefully there's some licensees out there that are hearing this and it's helpful to them, because we would really like to get a 100% pass rate on this and for it not to be that big a question.
I have a question as a non-psychologist, just out of curiosity, though. Is it best that they just run it by the office, whatever they're taking, or?
I would think on behalf of staff I could say no.
We have approved providers
Oh.
for continuing education. And so as long as a psychologist goes to a course or a workshop or whatever that has been approved by one of those providers, their CE counts. And it tells you on everybody's brochures and information and all like that, who's approved them for continuing education.
Oh, I was
So
just.
it's not hard.
Oh, well, just like in the case that Dr. Phillips just brought up, like how, because you're in a more specialized, it sounds like, how do you?
Well, I just make certain whenever I take a continuing, I'm going to count toward hours. Sometimes I'll take the course simply because I'm interested in the subject matter.
Oh.
If I'm going to take the course and use it for continuing education hours, I make sure it says it's an APA approved, a CPA approved, what was
ACCME.
AMA or ABCI.
Registered nursing
Yeah.
sometimes too, and CME.
Yeah, so you just make sure that those hours have
Not for
an
us.
actual,
mean, we'll
it
see
indicates
them
on the
on there.
certificate, and it indicates on the registration that it's got the appropriate, it's not that difficult to figure out.
And most people get more hours than they need. So a lot of times people go to stuff like that. That doesn't count toward licensure, but it's really in your area and you really want to know it and all that kind of stuff. So
I'd add one more thing, and that is that there is now a policy that for licensed board members, when they do their licensing renewal cycle, they will automatically be audited, so that we'll be as transparent as possible about this whole process and don't want licensees to feel that somehow they're being singled out and we kind of skate by the boards. So I think maybe I will be the first one to come up
Yes.
as my license renews in May. One of the common errors that people make, which I should add, as long as we're doing something educational, is that people will send in their licensing renewal, saying that they've completed their hours, and then they will scramble to get hours after that, before the license expiration.
That's what I was
is.
just, have been asking, but it sounds like that's not happening now. I had heard that was happening, too.
It's come up a few times, hasn't it?
I would say, having been the manager prior to Lizelle's coming as well, it used to be a little more common a few years ago. So when I first arrived as the manager of central services, we were seeing a lot more of those and sending out a lot of educational letters. And there's quite a bit less of it now. I think the word has gotten out. Enough educational letters have gone out, so people are, when you sign, that's when it means it. Whenever we get phone calls about it, that's what we tell licensees over the phone and on email as well. So, and then Lizelle, if you'd like to make a distinction on.
Oh, yes. So registered nursing isn't an approved provider, but CME is. So I would just make sure you contact the provider to know that if it's CME.
I was just
Yeah.
mentioning that when you look down the list, these are all these things you could possibly see. But we have to look for ones that work for us. Yeah, sorry for the confusion.
Any more questions? Any public comment? Thank you very much, Ms. McCochran. Okay, well, we're going to just keep plowing ahead, see if we can get some of this stuff done. We're going to jump around again, and we are going to go to the regulatory update, which is item number 24. Mr. Fu.
So item 24 is page 428 of your combined packets. And this is an update related to our regulatory packages and their status currently. And you'll notice from our last board meeting in February that we have one item that has moved on to the initial departmental review stage. That's item B, which is the standards of practice for telehealth. So I'm sure that Dr. Phillips and company are pleased about that, and given their work related to telehealth as a committee, and Dr. Erickson, of course. And other things of note from our last board meeting in February is that several of the regulatory packages have been submitted for legal counsel review, and we're waiting to hear back for that. Are any additional comments from Ms. Burns about the regulatory update?
No, you did a great job.
Oh, thank you. Any comments from board members? Public comment?
I think I might have mentioned this last time, but I just want to reiterate again, for completing the package for continuing professional development, Dr. Horn spent several hours with staff helping us come up with some of the whys. We can certainly articulate the fiscal impact and the staff and the breeze impact, but when it comes to the policy discussion of why we're making some of these changes, it was so helpful to have Dr. Horn in the room helping us do that, and like I said, several hours. So I just want to say shout out again to Dr. Horn, and I really appreciate the time you took with us.
Thank you, Mr. Fu. And it's going to continue to be, you're continuing to be in the hot seat. We're going to go to item number 22, the Policy and Advocacy Committee report. We're only going to address a portion of that at the moment, and then we'll come back and address the remainder of it likely tomorrow.
So we're going to get a little complicated here. So we are going to take on item 22, but we're going to start actually under subsection C2, which stands for newly introduced bills, potential action to recommend the board watch bills. And once I have a page number for you on your combined packets.
Page 204.
204, thank you, Ms. Burns. So, and to further complicate things, we're actually going to take on items starting at the Melendez bill, so item D, because items A through C have a recommended board action that I think we might want to save for tomorrow, as folks might be attending with public comments on those. So we'll start with items D through EE under that section. These are watch bills by the committee. We aren't going to go through them one by one. However, it's an opportunity for any board members upon review of the bills, when you receive a board packet, to call out any particular bills that you would like to discuss and potentially recommend for action based on that reading. The policy committee, the Policy and Advocacy Committee did review the watch bills, all the bills that you see before you at its meeting last month, and made no recommendations to changing the position of those bills from watch to anything else. So are there any items in subsection C2, starting from item D with AB 71 through item EE, which is SB 639 by Senator Mitchell, that you would like to pull out for discussion? Sure. So starting with items the last bill is item EE, Senate Bill 639 by Senator Mitchell, related to medical services, credit, or loans. Was that a bill that you wanted to pull out?
Oh, no, I'm just
Okay.
see how far. Do you have a combined page?
For the last item, it is going to be
Oh, I see it. Thank you very much.
393. And it's typical practice for us, for the watch bills, for us to just group them because the volume, as you can see, is tremendous. But with items that are recommending a particular board action, like the items beforehand, those will be discussed on a one-by-one basis, so that you have the so we all have an opportunity to discuss the ones with recommended action. The watch bills under this section, staff have reviewed them with no recommended change of position. The committee reviewed them in March on a one-by-one basis. The committee consists of Dr. Phillips and Dr. Kasuga, as well as myself, and previously Ms. Jones before. And so we do group these bills for group discussion, given the volume.
And these are all ones we already agreed to a watch position.
Correct.
Right.
And there's no formal action required from the board for watch, but it is put on the list that Mr. Glassbeagle sends out every Friday afternoon along with all the regulatory packages and updates that we have. And that's a useful tool that I know I certainly appreciate every Friday that Mr. Glassbeagle does. So many thanks to you, Ms. Burns, and Mr. Glassbeagle for that. So, while the board continues to look at the watch bills, is there public comment more broadly on the items that 22C to D through EE? Seeing no public comment related to those bills, is there any board discussion related to any of the volume of the bills identified before?
Doesn't appear so.
So we're going to move on from that to the next section, which is section 3, which is newly introduced bills, potential action to recommend the board watch spot bills. It begins on page 398. Thanks, Dr. Horn, who's faster with the PDF than I am. So items begin. Is that a sponsored ad? So starting with AB 5 by Assemblywoman Gonzalez, and ending with item Q by Senator Durazzo. Again, these were spot bills that have now language introduced in them. There was a deadline in the legislature last March for spot bills to have amended language to make them substantive and to be able to refer to committee. These bills here are informational only as well, and that's something that the policy committee and staff will continue to also monitor. Any questions from the board related to these items? Any public comment?
And I would just mention as staff that some of these bills will fall off. Now that they have language that no longer applies to the board, we'll start removing them from there. At the time that we made the agenda, obviously, we included all of these because it's done a lot further ahead. So a lot of these that are no longer relating to the board or DCA or our licensees or the practice of psychology will all fall off your list in the future.
I have a question. Can you say again what a spot bill is?
So a spot bill is generally, if you think of any bill, it's just a vehicle for legislation. So they'll introduce a bill number and maybe change an and to a or, maybe add a comma. It's a very non-substantive change, or it'll say the intent of the legislature is to do something. So they put language into a vehicle until they can put the actual worked out language that they have, because you have to introduce a bill by a certain deadline in February. Everybody's got to get those bill numbers out because you only get that many. And then once you have that out there, you can go ahead and put language into that vehicle. So spot bills are usually ones that were just an empty vehicle or vessel at that time. And then, of course, just because of the way we have to prep our agendas and get sign off and everything, they were still spot bills at that time.
Meaning
They were empty vessels.
Okay, I put this out there, it's going to be about this, but I don't have the language worked out yet.
Yes.
Okay.
Or it may
I'm
not
just
even
saving
be
a place for it.
Exactly. It's a placeholder.
Okay.
Sometimes it does give an indication of where they're going, and sometimes it moves from DCA to water or DCA to highways. So it can be all over the map, really.
Dr. Harpsheets?
On AB 5, could you tell us the current status of that bill?
I do not have that in front of me. I can pull it up. I did it the other day. Let me pull it.
I guess in the meantime, maybe, Dr. Fu, could you tell me how your committee is looking at this bill as it relates to the practice of psychology?
Sure. So the bill we're currently watching the bill for potential impacts related to psychologists and their psychological assistants. And this is related to a Supreme Court case, the Dynamics case that is often referenced. This bill is attempting to encode the test that was established by the Supreme Court into state law. And there have been other competing legislation to take on a different test as well. And so while this bill continues to move through the process, we are watching it. I know Ms. Burns is pulling it up on LegInfo.
It's in appropriations right now, and it's in its own house. It doesn't have a hearing scheduled yet, but we're not up against the fiscal deadline yet. So it'll be heard in Assembly Appropriations. And of course, we're watching these because it may impact that relationship between our licensees and their supervisees. But this isn't something that as a regulatory body we feel we have to put our regulatory input into. So this is the employment relationship, not something that deals with what licensing has to be concerned about, which is your supervisory guidelines and the rules for supervision.
So the focus in this would be, for the board, would mainly be the relationship as defined between the supervisees and supervisors in psych assistant situations. Do you see in any way how it might impact licensed psychologists who are working in jobs as independent contractors?
Can I take this?
Sure.
In all likelihood, if they were to change the definition of what an independent contractor is, it might no longer be an employment relationship or may continue to be an employment relationship. We're not particularly concerned as a consumer protection board with what our psychologists have to deal with relative to taxes and employee status, but we do want to watch it so we're aware of it, which is why it's on a watch status. Typically, if someone was going to take a position on this, it would probably be a professional association.
Okay.
Because they're the ones that advocate on behalf of licensed psychologists.
Okay, thank you.
And I think, as Ms. Burns mentioned, because the bill's not key fiscal, it's not going to be heard. There's a deadline that they're running against tomorrow to move all bills out of Appropriations Committee for fiscal bills, I think. Or, excuse me, policy committees have to report out to the Appropriations Committee by the end of this week for that. So I think that will be probably the first priority for that. Is that correct, Ms. Burns?
Yeah, and this bill is already sitting in appropriations,
Yep.
so it's squarely already in that committee's jurisdiction. So they can take it up, I think, any time in the next month. So
Well, in their own house. It looks like Friday's the last day for policy committees to hear a report to fiscal committees, fiscal bills.
this one's already in a fiscal committee.
Oh,
So it's
okay.
already
So
in.
May
Yeah.
17th is the last day for
I
fiscal
have those calendars
committees.
in the box.
Yeah.
I didn't fill them out because I didn't think we were covering this.
So Ms. Burns provides legislative calendars for us so that we can track the process. And as mentioned previously, it can be a fairly aggressive timeline. And we do try to time our policy committees to be as aligned with that calendar to the extent possible so that we can be nimble to respond to them as needed. Are there any additional questions related to items in that C section that were previously spot bills and now have been amended with more substantive language? And I think we already called for public comment, so I'm going to turn that over to you, Dr. Phillips, since that's the conclusion of this section.
We could do our sponsored bill update.
Oh, okay.
It's an update.
Sure, so that we're going to jump back up to, so apologies for more jumping. We're now going into 22B, which is board-sponsored legislation for the 2019 legislative session. There are two bills there, SB 275 PAN, that's B1, and on the combined packet, we will raise Dr. Horn to see.
86.
88. Oh,
The bill is 88. I think the 22B1 is, the memo is 86.
we'll call that a tie. And
Go Microsoft.
so, Ms. Burns, would you like to provide an update on our sponsored bill? This is 22B1, page 86. Thank you, Dr. Phillips, on our combined packet related to sexual contact.
Absolutely. So SB 275 is our sponsored bill to add sexual behavior to 2960.1 of the Business and Professions Code, so that acts of sexual behavior would be treated just the same as any sexual misconduct that includes sexual contact. Those provisions went through the Senate Business and Professions Committee on April 1st, 2019. Dr. Phillips came up and got to give a very short support.
I just appeared.
And we got moved to the end of that agenda due to some other controversial items on their agenda. So we went through Senate Business and Professions and Economic Development quickly, and because our bill is not fiscal and it has no fiscal impact, it's called a 28.8 rule, where the Senate just passes it right on through. The Assembly doesn't do that. They still make their Appropriations Committee hear things. They put it on consent, but in the Senate, they just send it off to the floor. So we are now to the floor, and it can be heard anytime in the next couple weeks, I believe. So we'll wait for that and get through the Senate floor hearing, and then off to the Assembly, hopefully.
I guess the only thing I would add to that is that there was no opposition to our bill. The California Psychological Association took a neutral position on the legislation. So we're anticipating good things. Things can change, obviously, but it seems to be headed in the right direction.
Absolutely. And you got very good receptions from a lot of the senators in business professions and economic development. So,
And Senator Hill in particular said, complimented the Board of Psychology in leading the way of the consumer protection boards for being more inclusive in what is considered inappropriate sexual behavior. And he expressed hopefulness that other boards will follow suit.
And I think part of the groundwork that was laid was in February related to this, where we had several board members do legislative meetings with the Business and Professions Committee. So the work started on this well in advance, and I know several board members here participate in those meetings. At the risk of always forgetting people, I won't name those persons, but if you would, as those who did do legislative visits would like to make comments on this particular bill, please feel free to do so.
Just that during the meetings, I don't remember anybody who was not receptive, and also appreciated understanding what that meant in the context of consumer protection and the therapy relationship. So that education piece of it, I think, was really useful.
Thank you, Dr. Herbsheets. Public comment on this item? Seeing none, no board discussion, I see. Oh, sorry, Ms. Orrick.
Really quick, I just want to kind of say another plug for our legislative visits, because I think, Mr. Fu, as you pointed out, it's so important that we keep relationships with the Business and Professions Committee staff and the members so that they understand what the priorities of the board are. And when we're able to lay groundwork for the upcoming legislative session, it's so nice having that seed sown early, so that it's not the first time they've heard something when we come and testify at a committee meeting. So thank you to all of you that participated in those meetings.
Typically the Wednesday before our first board meeting in Sacramento, if you would like to join the party for next year, 2020. So item 22B2, this is an update on amendments to the Business and Professions Code. This was an omnibus. The board had submitted to the committee 3 provisions. One would be cleanup language related to the EPPP. The second related to voluntary surrender, and the third related to temporary practice. The feedback we received from the committee was that the provisions related to voluntary surrender and to the temporary practice were considered substantive, so they won't be able to go in for this year. It will be something I think that we will look forward to in our 2020 discussions. But the EPPP cleanup did make its way through the omnibus, so that's in there for that. And just as background, the voluntary surrender was something that the licensing committee had been working on, if I remember correctly, being on the licensing committee as well. And it's something that we have been trying to deliberate over to provide an avenue for a person to surrender a license without a discipline attached to it. And then the temporary practice piece was, and I see Dr. Phillips might go up, so I'll wrap up real quickly, but the temporary practice piece was recommended language that we heard from the CPA, California Psychological Association, to clarify what temporary practice would look like for the 30 days. Both were considered too substantive for the omnibus in this particular case. Dr. Phillips.
Just to clarify, it was actually for voluntary surrender. That was actually in the Enforcement Committee. So shout out to the Enforcement Committee. And I think the other piece you were discussing was in Licensing Committee.
Great. Ms. Burns, did I miss anything in that update?
No, not at all.
Okay,
Not at all. And then by the next board meeting, we'll obviously have a bill number to report on for our examination provisions that are included in the omnibus. So just as a reminder, our provisions will be one of many in a very long bill. So we'll probably be one little section of that. So.
And I just wanted to clarify that the voluntary surrender piece was just to clarify in our Practice Act a process for reinstatement of a license for those that enter through voluntary surrender, but we still have that mechanism for individuals that would qualify under those circumstances. So that hasn't changed because of the bill. So I just want to clarify that.
Thanks for that clarification, Ms. Horrick. And just because I know the EPPP tends to draw a lot of attention, this was recommended language from the task force that went into the cleanup bill. and the recommended language from that task force, which is chaired by Dr. Kasuga, removed outdated requirements and made remaining provisions consolidated, more concise, and more easily understood by consumer and applicants. So these were non-substantive changes and says nothing about the adoption of the EPP2. Seeing no public comment or board discussion, I turn it back over to Dr. Phillips. Oh, goodness. Sorry about that. We're going in reverse order today in this section. So, this is item 22A, reviewing consideration of provisions to the goal of the Policy and Advocacy Committee. This is page 85 on your combined packets. So at our March 18th, 2019 committee, we discussed updating the goal and name of the committee. And so what you see before you is a revised committee name from the current title, Policy and Advocacy Committee, to what the committee is recommending, Legislative and Regulatory Affairs. And the second is, you can see before you on that page, language for the revised goal, which I won't read aloud given the underlines and strike-throughs. But the logic behind the name change is in our December meeting for our strategic session in December, upon review of the survey information that Solid did, or as well as the focus group and stakeholder input, there seemed to be a confusion about what the committee did in terms of its policy work. A lot of the stakeholder input we got was that the committee wasn't doing enough to advance bills that traditionally would fall under the wheelhouse of the professional association. So things that would advance the individual practice, a person's practice, I should say, the professional practice. And so we thought we would clarify that, that confusion by changing the name from Policy and Advocacy, which I think does suggest in many ways a approach to advancing or being proactive about the trade association pieces, to what we actually do more, which is the legislative and regulatory affairs portion of that work. So that's the logic behind that committee change, name change recommended. And then the second, the revised goal there is a product of the December meeting as well, and to more fine-tune our goal to reflect what we actually do related to recommending position on legislation, and working with all the other committees for regulatory packages, et cetera. Dr. Phillips, being on the committee, do you have any comments?
The only other thing I would mention is that I think calling it the Policy and Advocacy Committee also suggested we were in charge of policy. And actually the board as a whole is the policy-making body. So I think on a lot of levels, the name change is quite appropriate and much more accurate.
Dr. Kasuga is also on the committee, and this came out of the policy committee with a 3-0 vote to make those changes. Any board discussion or feedback on our wordsmithing? Dr. Tate?
All I was going to say was kudos to the group for taking the information in, making the changes, and implementing. Good job.
Thank you, Dr. Tate. Ms. Marks?
Hi, I'm sorry, I was not present at this particular meeting, so this is really my first chance to look at it. I was just looking at some of the what looks like a little bit of a grammar issue that I might want to point out. It's on the last line, or starting with the last sentence. It says the committee also recommends and informs the board on regulations, and grammatically, I'm not quite sure that follows. It recommends positions on regulations, or recommends, because it's not really a position on a regulation, so I'm not, I was just going to suggest that maybe that be refined a little bit.
I had, based on feedback from Ms. Marks yesterday, just come up with something for possible consideration. In that sentence, you could consider the committee also may initiate and inform the board on regulations.
So you can initiate regulation regulations or about regarding?
Does that say, the way that you
The
read it,
wordsmith
Ms.
too
Ork,
much.
does it say initiates regulations? Can you read it again?
So the committee also may initiate and inform the board about regulations. And I think what the discussion that we had on that day was that even though typically you'll get regulatory language from either the licensing committee or the enforcement committee, bless you, it can also come from the Legislative and Regulatory Affairs Committee. So I think we wanted to allow for room for that because there have been a couple situations where I think we got, for example, some regulations, model regulations from ASPBB that at that time, that former committee looked at that and then brought a recommendation to the board or thoughts to the board about it. So we just wanted to make sure that that this committee had the ability to take a first crack at language for regulations if appropriate, or to follow regulations through the process once it had been initiated. No, go ahead.
How about the committee may also recommend regulations and inform the board about the status of regulatory packages or positions. But you're also talking about recommending legislation itself or recommending positions on, what are you talking about?
This part is just about the regulations. The prior sentence is about legislation.
Right.
So,
I might suggest that oftentimes we're recommending changes to regulations, so amendments. So maybe it's the committee may also recommend amendments to and inform the board on regulations and the status of regulatory packages.
I would say changes rather than amendments, because but anyway.
And does that include regulatory language? Is that broad enough to include regulatory language?
It doesn't sound like that language would speak to the initiation of regulatory packages within the committee. So I don't know how we fashion that piece in there.
Yeah.
Could y'all redo the last sentence?
what we could do is, since we are so efficient on our agenda, we can brainstorm and bring this up for tomorrow if this piece
Good.
is something that we're stuck on.
That's great.
Dr. Harp, I saw your mic go up. Did you?
No, I had said what I wanted to say, and then I turned it off.
Oh, no worries. So I think we're going to move this item till tomorrow for further discussion and just to sleep on it. I think the last sentence language I have, based on what Ms. Sorek and Dr. Horn has suggested, is the committee may also initiate and recommend regulations, suggest changes to regulations, and inform the status of regulatory packages. So I know that's not final, and I know there's a lot of.
Sounds good.
Do we want to sleep on it still?
Could you read it one more time?
Sure, and I do want to point out we use the word regulations very frequently, but to be fair, this is a sentence about regs. So the committee may also initiate and recommend regulations, comma, suggest changes to regulations, comma, and inform the status of regulatory packages. Ms. Marks?
The committee cannot initiate regulations.
Oh, so.
Committee can recommend to the board that it direct the staff to initiate regulations, but the committee can't do it.
So that would be the committee may also recommend regulations to the board, or hold on, the committee may also recommend regulations, suggest changes to regulations, and inform the status of regulatory packages.
And inform the board about
Yeah.
regulatory status of regulatory.
So, I just have a question. When you say suggest changes, or how you said that, does that include the regulatory language or just the ideas? I guess I wanted to make sure, since the committees may suggest language, that statement includes that piece. Is that too fine of a distinction?
No. I think this further discussion has indicated to us that it's a good idea for us to sleep
Yes,
on
we're
this
going to go
over.
back to sleeping on it. So we will hold this item for tomorrow.
Did you want to entertain a motion about the name change?
Oh, okay. So while we sleep on the second portion of our revised goal, I certainly would welcome a motion to adopt the revised Policy and Advocacy Committee name.
I move.
Second?
So we have a motion by Dr. Harpsheets, a second by Dr. Tate. Ms. Burns?
Akoy-Badu?
Yes.
Oh, actually, I should have called for
Public comment.
public comment. Sorry, I got ahead of myself. Is there public comment related to the name change of the committee? Is that a public comment?
No.
Seeing and hearing none, returning to the board for discussion. Seeing and hearing no discussion from the board. Ms. Burns, could you please, and we do have a motion from Dr. Harpsheets and a second from Dr. Tate. Ms. Burns, could you please call the roll?
Akoy-Badu?
Yes.
Bernal?
Yes.
Fu?
Aye.
Harbsheets?
Yes.
Horn?
Aye.
Phillips?
Aye.
Tate?
Aye.
Motion passes.
Thank you so much, and we will return to the revised goal tomorrow. Dr. Phillips.
Thank you very much, Mr. Fu, particularly for your flexibility and playing a game of Twister with the agenda. It is now about 35 minutes after the hour. We have a petition hearing scheduled at 11, so we're going to take a 25-minute break. Please make your best efforts to be back here by 11 a.m. so we can start on time. Thank you. Just a couple pieces of housekeeping. I did want to mention that although it's not explicit on the agenda for tomorrow, we will be having public comment for items not on the agenda, so that matter will continue over to tomorrow. We're now going to go into the hearing on the petition of Dr. Amy Reyes. I will tell you that we're going to call roll, but we're going to wait until we're on the record to call roll so that it serves both of our purposes.
All right, very good.
Thank you.
Good afternoon. My name is David Rosenman. We're going to open the record, and this is on the petition for early termination of probation of Amy Reyes, the Office of Administrative Hearings. File number is 2019-030499. This hearing is before the Board of Psychology, which is meeting at the Los Angeles Hilton Hotel, and today is April 25, 2019. I'm going to turn the proceedings back to the president for purposes of taking a roll and establishing that there is a quorum for purposes of the hearing.
Ms. Burns, would you please take the roll in the order that our videographer would like it?
Bernal?
Here.
Horn?
Here.
Fu?
Here.
Phillips?
Here.
Harbsheets?
Here.
Tate?
Here.
A quorum being present, I will turn it back over to the judge.
Thank you very much. Again, my name is David Rosenman. I'm an administrative law judge with the Office of Administrative Hearings in the Los Angeles office. I've been assigned to preside over the hearing today, which again is in front of the Board of Psychology. Let me ask Ms. Amy Reyes, who is the petitioner, to please identify herself for the record.
Good morning. My name is Amy Reyes.
Thank you. And the representative on behalf of the Attorney General's office, would you please identify yourself for the record?
Yes, good morning, Your Honor. It's going to be all morning. Good morning, Your Honor, members of the board, Deputy Attorney General Brian Bill on behalf of the Attorney General's office.
All right. I'm actually going to give an instruction to the court reporter, and it gives me an opportunity to remind everyone that these proceedings are being reported or recorded, not just for the webcast, but for court reporter purposes. A couple of rules. Please try not to speak over each other. It makes it very difficult for a clear and clean record to be prepared. Excuse me. Also, and this is for the court reporter, we have two different proceedings. One set at 11 o'clock this morning for Ms. Reyes. We have another in the afternoon. Is Ms. Spitz here? She is not. That's the petitioner in the afternoon. I may have a limited ability then to incorporate comments I'm making now into this afternoon's proceedings or transcripts. So the first few things I'd like to do is give the board members some information and the opportunity to ask questions or provide information. This is just of a very general nature. I know that the board had hearings for reinstatement petitions or petitions yesterday. Is there any board member here who was not present yesterday and did not participate in that process? No show of hands. So you have some familiarity with the process, whether it was from yesterday or from prior meetings and hearings. Nevertheless, each judge handles some things differently, and I also want to make sure that we've established a basic set of ground rules. So I'm going to repeat a couple of things that you're all probably familiar with, but I think it's important both for board members and for Ms. Reyes to know that these are some of the rules that apply for this process. In this hearing and decision-making process, the board members act like jurors. And just like jurors, you should not make any judgments until all of the evidence has been received. You have to base your decision only on the evidence that is in the record today, and that would be the documents that have been prepared that Mr. Bill will be presenting formally in a few minutes, but all of the board members should have already received and hopefully reviewed, and also on any questions, answers, testimony that's provided today. If any of the board members present were involved in the prior decision affecting Ms. Reyes' license, I have to again stress that your consideration of the petition today has to be based on what occurs today. You essentially have to wipe the slate clean, although in introducing and presenting documents, I'm sure you'll see things that are familiar if you were in fact board members when the initial disciplinary action was taken. I'll also remind board members that they also act like judges. They must be fair and impartial. You cannot be biased. On occasion, I have had a board member who has, at the outset of a hearing, indicated that that board member does not feel that he or she can be unbiased for whatever reason. So I'll ask if any board member feels that they, for whatever reason, may not be able to act neutrally and without bias, please let me know and we'll discuss whether recusal of that board member should take place. There is no show of hands, so we'll proceed further. What I anticipate the order of events will be that Mr. Bill will begin by presenting the documents that establish the reason for all of us being here today. Then Ms. Reyes will have the opportunity to provide a statement under oath. And then if Mr. Bill has questions, he has a chance to ask. If board members have questions, they have a chance to ask. What I tend to do is somewhat arbitrarily start either on my left or my right, go through board members, and then go through again, because on occasion something that someone after you has said sparks a question or concern, you get a chance to ask again. And then we'll come back and give Ms. Reyes the opportunity to add anything, Mr. Bill the opportunity to ask further questions, and once more through with board members in an attempt to be thorough. I will make rulings upon whether questions are proper or improper. I may do it without Mr. Bill's allowed to make objections. I may interpose an objection if I'm concerned that something's happening may affect the due process provided to the petitioner. I will interject with an objection or a comment and try and direct us in the appropriate manner. Board members must be present for the presentation of all of the evidence, the testimony and the documents, to be able to then engage in discussion and vote. So let me be more specific. If any board member needs to make or take a phone call, ask me for a recess, and that way we can recess the hearing, you can take care of that business, and then come back in. You should not be looking at texts or social media that is irrelevant to this proceeding. I realize that board members have tablets or laptops, and of course your materials may be on the laptops, but I don't want a repeat of a circumstance of a board member who was texting while sitting next to me, and I had to inform him that he could not vote. He was not happy about that. So let me find out from board members if they have any questions. I should say that once all of the documentary and testimonial evidence is received, the board will go into executive session for further discussion and ultimately a decision that will be issued. Do any board members have any questions of me about anything I've said about the process or anything else about the process, whether I've said something or not? I see no show of hands. Ms. Reyes, do you have any questions about the process that I might answer for you at this time?
I guess my only concern at this point is that I may need some guidance as to when it's my turn to share and I guess tell my story.
Certainly.
Because as you can see, I'm doing this solo today.
That's fine. As you've seen me do already, I tend to give instruction, and I will definitely address that. In relatively short order, you'll have the chance to present your case, so to speak. And I do want to encourage you during the course of the hearing, if there's something that happens and you don't understand or you need further information, please ask. Excuse me, Judge, can you tell me what this means or how I go about doing this, just as you did. So I want to make sure the process is as understandable as possible. Mr. Bill, any questions or comments before we get to the presentation of the jurisdictional documents?
No, Your Honor.
All right. So again, the first step will be for Mr. Bill to present the documents formally, even though all board members and I have received copies of your petition and the supporting papers. We need to formally establish that there's a proper basis for us to go forward today. So Mr. Bill, let me have you go forward with that process.
Thank you, Your Honor. I would like to mark for identification Exhibit 1, the petition for early termination of probation, AGO 001 through AGO 045.
And am I correct, Mr. Bill, you've given a copy of this same notebook with Exhibits 2, Ms. Reyes?
Yes, Your Honor.
All right, so Ms. Reyes, you have a notebook in front of you. Mr. Bill is now referring to the documents that are behind tab 1. Let me explain that there's a formal process for these documents to be considered. The first is for me to mark it for identification. That's simply recognizing a number that's being assigned to it. At some point, Mr. Bill, in all likelihood, will ask for a document to be received in evidence, and you can raise any question or objection, or you may not have any objection. Most of these are documents that you've gathered, so I wouldn't expect objection, but every now and then there's a question raised. All right, so the document that Mr. Bill has just described will be marked for identification as Exhibit 1 to these proceedings. Go ahead, Mr. Bill.
Yes, Your Honor. It's the petition for early termination of probation, and I would ask that the court move this into evidence.
All right. And Ms. Reyes, do you have any objection to the petition being part of the evidence that the board can consider today?
I do not.
Thank you. So Exhibit 1 is being received in evidence. Go ahead, Mr.
I would like to mark Exhibit 2, notice of hearing and the proof of service, as well as the request to set.
All right, so the documents that Mr. Bill has just described are behind tab 2. They'll be marked for identification as Exhibit 2 to these proceedings. Take a quick look. All right, what's next, Mr. Bill?
Your Honor, I ask the court to move item 2 into evidence.
And Ms. Reyes, do you have any objection to the board members reviewing and using Exhibit 2?
I do not.
All right. Exhibit 2 is received. I'll note for the record that in my preparing for the case, I saw that there was a page of board guidelines relating to argument that are essentially there to assist petitioners such as Ms. Reyes. I do see that in Exhibit 2. I wanted to make sure that the record was complete. Go ahead, Mr. Bill.
Your Honor, I'd like to mark as, for identification, Exhibit 3, the certificate of licensure.
The document described by Mr. Bill is marked for identification as Exhibit 3 to these proceedings. Go ahead.
I'd ask that the court move item 3 into evidence.
And Ms. Reyes, any objection to the board members using Exhibit 3?
No.
Thank you. Exhibit 3 is received in evidence. Go ahead.
Your Honor, I would ask that the court mark for identification Exhibit 4, the modified citation order dated July 2nd, 2018.
The document described by Mr. Bill is marked for identification as Exhibit 4 to these proceedings. Go ahead, sir.
I'd ask that the court move item 4 into evidence.
And Ms. Reyes, do you have any objection to Exhibit 4 being used by the board?
I do not.
Thank you. Exhibit 4 is received. Let me ask a question. Mr. Bill, I see that you have 11 potentially marked exhibits. Do you intend to ask for each of those to be received in evidence?
Yes, with the exception of item 11, I would ask that the court accept that as under seal.
All right. We'll get there. I won't necessarily wait for the two-step process and just go right to questioning Ms. Reyes whether she has any objection to documents, but we'll do that ongoing. Go ahead, Mr. Bill.
Do you still want me to identify the?
I would.
Okay. I would ask that the court mark for identification item 5, the certified decision in order in the matter of petition for early termination of probation dated January 10th, 2018.
The document described by Mr. Bill is marked for identification as Exhibit 5 to these proceedings. And Ms. Reyes, do you have any objection to the board referring to this document?
I do not.
Thank you. Exhibit 5 is received in evidence. Go ahead.
I would ask that the court mark for identification the stay of decision dated August 21st, 2015.
The document described by Mr. Bill is marked for identification as Exhibit 6 to these proceedings. And Ms. Reyes, do you have any objection to the board using and considering this document?
I do not.
Thank you. Exhibit 6 is received. Go ahead, sir.
I would ask that the court mark for identification Exhibit 7, the decision and order dated July 23rd, 2015. It's a single page, Your Honor.
All right. The document described by Mr. Bill is marked for identification as Exhibit 7 to these proceedings. Ms. Reyes, any objection to the board considering Exhibit 7?
No.
Thank you. Exhibit 7 is received. Go ahead, sir.
Your Honor, I would ask that the court mark for identification the probation report dated March 12th, 2019.
The document described by Mr. Bill is marked for identification as Exhibit 8 to these proceedings. And Ms. Reyes, any objection to this document being considered by the board?
No.
All right. Exhibit 8 is received in evidence. Go ahead, sir.
Your Honor, I would ask that the court mark as Exhibit 9 the probation profile.
The document described by Mr. Bill is marked for identification as Exhibit 9 to these proceedings. And Ms. Reyes, is there any objection to these documents being considered by the board?
No. I just see a name on here for my supervisor that's not correct. I don't know if that matters.
Okay.
For this.
Bear with me for a moment. There are page numbers that are at the bottom. Can you tell me what page you're referring to?
089, and
Okay.
it's Marissa, not Marcia.
I see. All right. What I will probably do, Ms. Reyes, is once you're under oath, give you the opportunity to make that correction.
Sure.
All right. Bear with with me for a moment. Other than that comment, any objection to the document being considered by the board?
No.
Thank you. So Exhibit 9 is received in evidence, and we will take testimony relating to the correction at a later time. Go ahead, Mr. Bell.
Your Honor, I would ask that the court mark item 10, the chronological record and quarterly reports.
The documents described by Mr. Bill are marked for identification as Exhibit 10 to these proceedings. And Ms. Reyes, do you have any objection to Exhibit 10 being considered by the board?
No.
Thank you. Exhibit 10 is received in evidence. Go ahead, Mr. Bill.
Your Honor, I would ask that the court mark for identification Exhibit 11, the psychological evaluation.
The document described by Mr. Bill is marked for identification as Exhibit 11 to these proceedings. And Mr. Bill, you had some further comment on this. Please go right ahead.
Yes, Your Honor. If the court receives this document as evidence, I would ask that the court seal this exhibit.
Okay. And am I correct? Mr. Bill, this report was prepared pursuant to a term and condition of a prior probationary order?
Yes, Your Honor.
All right, thank you. So, Ms. Reyes, and also, Mr. Bill, am I correct that you want this to be received in evidence but under seal?
Yes, Your Honor.
Okay. So let me explain, Ms. Reyes. As I've just asked, this was apparently prepared, and you undertook the examination under the terms of a probationary order that had been issued previously. Because reports of psychological examinations often contain information that might be considered as privileged or confidential, Mr. Bill has asked that the document be sealed. And what that means is that I would physically put it in an envelope, that actually there would be a separate written order that would be issued, that would be sent both to you and Mr. Bill, indicating that the document is being sealed. The board obviously is allowed to consider it, to unseal it, and if there's any proceedings on this case beyond the board's decision-making process, whatever entity, Superior Court or other, would also have the opportunity to review the document, but otherwise it would remain sealed and confidential. Do you have any question about that?
No.
Do you have any objection to Exhibit 11 being received in evidence and sealed?
No.
Thank you. Exhibit 11 is received in evidence and it will be sealed. All right. Mr. Bill, anything further before we get to testimony from Ms. Reyes?
If I can make a quick opening statement, just
Sure.
to lay everything out for the board.
Go right ahead. Let me remind board members that this is not testimony. It's Mr. Bill providing board members with information that might be helpful as contextual. Go ahead, sir.
Thank you, Your Honor. We're here today to determine if Dr. Reyes is entitled to the requested relief of early termination of probation. In this matter, Dr. Reyes applied for a psychological assistant registration number on January 31st, 2013. The board denied that request in October of 2014 based upon 2 driving under the influence convictions, one in 2003 and the other in 2011. On May 15th, 2015, Dr. Reyes signed a stipulation after the board filed a statement of issues. The board issued a license and immediately revoked the license, stayed the revocation, and placed Dr. Reyes on probation for 5 years. The effective date of that decision was August 22nd, 2015, and the anticipated completion date of her probation is August 31st, 2020. On September 6, 2017, Dr. Reyes applied for early termination. That was denied because the board was not convinced that Dr. Reyes owned her conduct. The board stated that Dr. Reyes was unable to acknowledge that she drank excessively during her 2 DUIs, and the board felt that Dr. Reyes failed to fully acknowledge the wrongfulness of her actions. You'll hear today that Dr. Reyes is in compliance with the terms and conditions of her probation, with one exception. She's received 1 violation for failing to attend an AA meeting during the week of March 4th through March 11th, 2018. The issue here today is Dr. Reyes's willingness to accept her conduct rather than her performance on probation. Her performance on probation has been satisfactory. If Dr. Reyes fails to establish her willingness to accept her prior conduct, then the board must weigh that refusal to accept willingness with her probation performance and determine if Dr. Reyes has proven her case. If you do not find that the lack of acceptance outweighs her performance, if you do find that the lack of acceptance outweighs performance, then you must deny her request. Thank you.
Thank you, Mr. Mr. Bill, I want to ask a question of you. If I understand correctly, the initial licensure or registration was by virtue of a stipulated settlement, is that correct?
Yes, Your Honor.
Thank you. And yet I don't see that in the exhibit package. I see the decision adopting the stipulation. Is there some explanation for that?
Your Honor, I don't believe that the underlying terms are the issue. I believe it's her mindset regarding acceptance. I don't think that her performance on probation is the actual issue.
All right. I raise it because in your comments and in the documents you indicate that there was one instance, and I believe a citation issued, concerning a failure to attend an AA meeting. And my understanding of how these things usually work is that's part of the terms and conditions of a probation. So I was just looking to make sure that the board members have enough information to fully understand the evidence that's being presented. So if I understand correctly, is it your understanding that attendance at AA meetings was a condition of the probationary license that was set forth in that stipulation that was subsequently effective by virtue of the board's decision?
Yes, Your Honor, and those terms and conditions are contained in the probation report in Exhibit 8.
Thank you. That is very helpful. All right. More correctly, we have a summary or titles of what each of the conditions were, but that's sufficient, I think, for these purposes. Thank you very much, Mr. Bill.
Thank you.
All right, Ms. Reyes, or Dr. Reyes, I apologize. To explain where we are and what happens next, Mr. Bill, in his opening statement, has just provided context for the board members of why we're here today. We are here today to receive and consider the evidence that you have gathered in your petition and any additional information that you want to provide to the board. So as you had asked previously, now would be the time for you to provide testimony. Because testimony is given under oath, I'm going to ask you to stand and raise your right hand so that I can swear you in.
Sure.
All right. Do you solemnly swear or affirm that the testimony you'll give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Please be seated. And for purposes of the record, can you please state and spell your name?
Amy A. Reyes, A-M-Y-R-E-Y-E-S.
And Dr. Reyes, while giving your testimony, keep a few things in mind. It's very common for people to be nervous, and I think all the board members understand that. Sometimes when people are nervous, their volume drops, so we may ask you to keep your voice up. Sometimes people will speak quickly, and we may ask you to slow down. Mr. Bill has the right to raise objection. If you hear him say objection, I'd like you to stop your testimony, and I can make a ruling and then give you instructions on how to continue. Once you're finished with your statement, Mr. Bill can then ask questions if he has any. Board members can ask. As I explained earlier, we'll go around a few times, and you'll have a chance to add anything further that you may have forgotten or that a question may have prompted.
Mm-hmm.
That being said, I'm sure the board members are very interested in hearing your testimony, so please go ahead.
Thank you. My name is Amy Reyes, and I am here to petition for early termination of my probation with the Board of Psychology. And since I was last meeting with you folks, I've had the chance to not only be a lot more involved with AA, the AA community, obviously, but gain a lot more of insight and awareness as to my struggles while, during the times where I was arrested for drinking and driving. And one of the things that I have grown to appreciate has been, how welcoming the people in the rooms have been, the people in AA have been, and the opportunity to be more present and an active member of AA. So I think I mentioned it in my statement with my application. I've had the opportunity to co-chair in 2 meetings, and also had the opportunity to do an in-house meeting, which I had never heard of. And that's when you actually go to someone's home and have a meeting. It was a rather small meeting. It was only 4 of us, but the fact that, it made me realize that there's a great deal of trust for someone to invite me to do something like this. And the reason why that happened was because one of the people in AA was actually ill. And as a supportive group, this is something that people in AA do. And so that was pretty interesting. And it was definitely heartfelt to actually be there. And although I don't have a commitment in AA, I try to go to the same meeting on a regular basis. I definitely go pretty much to the same location most often, but try to go to the same meeting. Although it's the same location, I tend to see the same people. And like I said, I've co-chaired 2 meetings. One was just the opening prayer, and that was easy. The second time I thought, oh yes, I can definitely do this. And it went sideways real quick, but they were able to support me through it, and it encourages me to actually want to be more present in that sense. And like I said, I don't have a commitment, but I do hang out after, put books away, fix chairs. I bring the good cookies because they're self-supported, so they don't always have the best coffee or the best cookies. I don't drink coffee, so they call me the cookie girl, which I'm okay with. But I just want to kind of summarize as far as, my involvement with AA. I've asked members of that community, shared my story and asked them about, their views about my struggle with alcohol and the role that it has played in my life. I don't get any clear answers from them. They see it as a self-diagnosed disease. And so, just within that, I've been trying to get some guidance and maybe a better understanding as to what role alcohol has played in my life. But aside from that, I'm just more involved with, self-exploration and getting to know me on a different aspect. Like you guys have read, I really have enjoyed nature and hiking, which is my therapy, my version of therapy on top of seeing my therapist. And I just feel that it has brought so much clarity. Definitely, not drinking has brought clarity and understanding, and being around alcohol hasn't been a problem for me as far as cravings or, wanting to kind of test the waters to see if I can have one drink or what have you. As I mentioned, I've been to weddings, I've had deaths, I've had a traumatic experience, and losses and so many different things that I had never even thought about alcohol being something that I want to resort to, not something that's in the forefront for me. I know that obviously it's been problematic for me, and that's not something that I'm willing to risk, nor do I want to. I don't want to even think about the possibility of drinking, because that's not something that is important to me at the time. Another thing that I have come to embrace more is spending more time alone, and it's been a challenge, but spending more time at home and not feeling like I need to be everywhere with people, celebrating, doing things, which has brought a lot of insight as well, as far as, you know, being able to be on my own and not need to be in the limelight of things. And just one quick thing that I want to share, and I don't know if I would have an opportunity to share this a little bit later, but maybe just do it now. I have he just turned 18 actually, an 18-year-old nephew, and I was talking to him a few months ago, and he mentioned FOMO. I don't know if you guys are aware. Well, I was not. And he enlightened me, and apparently it means fear of missing out. And so when he shared that, I thought, oh my gosh, that was so me back in those days, where I wanted to be at every birthday party. I wanted to be at every celebration and things like that. And I know that alcohol was highly available and, you know, maybe even encouraged. And I think that's one of the reasons why I've actually challenged myself into staying in and kind of doing my own thing. I've separated myself from the relationships and the friendships that involved a high amount of drinking. So now I have chosen to, you know, surround myself around people, who are sober and are more positive. I have a friend that's, you know, very much into meditation. I'm trying to get into it. It's a little difficult for me. Takes a lot of time and effort in my eyes. But I'm just trying to embrace new, healthier ways. And, you know, I think I have shown that I have been able to do that, and, you know, really that it hasn't been a problem. I wish you guys can get in my head so that you can understand my thought process and how much it has changed over the years, how I just feel that alcohol is a non-issue at this point. You know, and that doesn't mean that I don't own up to, you know, the problems that it did cause, and that I did in fact drink, sometimes more than maybe I should have or I wanted to, but I really don't see that as a problem now, both because, again, I have grown and understood, maybe appreciate more about the consequences of drinking alcohol, but also there's this forever instilled fear in me that if I do drink, something bad's going to happen. And obviously that's not what I want. I appreciate the opportunity of being able to continue to practice and do what I enjoy and love, and be able to help people of the community, and that's definitely something that I want to continue to do, and, you know, hopefully grow within that and begin to establish myself in this path, and hopefully put this behind me, in a sense that I don't have to maybe be reminded every day, you know, by having to check in if I have to test, or, you know, doing things that just feel, in a sense, intimidating to me every day. You know, it causes some sense of anxiety that I'm going to miss a testing day, or that I'm going to miss something, especially after I missed that AA meeting, which I really don't have a true explanation as to why that was missed. It just skipped my mind for some reason. But now I'm really cautious about documenting and writing down everything that I have to do as far as my responsibilities to the board. I think that's it for right now. Thank you.
All right. Thank you, Dr. Reyes. Before we have questions from Mr. Bill and board members, I did want to circle back to the comment that you had made about Exhibit 9. So if I could have you turn to the document behind tab 9 in your book. And I realize you stated this previously, but now that you're under oath, I'd like you to address the correction that you wanted the record and the board members to be aware of. Is this the reference to what's written here as Dr. Marsha Long?
Mm-hmm. Yes.
And what correction would you make to that?
It's Marissa Long, Marissa.
Thank you very much. All right, so now we'll have questions first from Mr. Bill and then board members if they have. So, Mr. Bill, go right ahead.
Thank you, Your Honor. Good morning, Dr. Reyes.
Good morning.
I want to talk about your rehabilitative efforts. First, AA. How often do you attend AA meetings now?
Currently, I'm attending 3 times a month.
And has that been your normal pattern throughout your probation?
No. I believe it was the first year and a half, I was attending on a weekly basis. And then following that for approximately another year, it was biweekly. And then most recently, it's been 3 times a month.
Okay. Now, there was a violation or citation issued to you in July of 2018, is that correct?
Yes.
And the citation was for missing one AA meeting that you were required to attend between March 4th, 2018 and March 11th, 2018, is that right?
Yes.
And I believe you said that you have no true explanation for missing that meeting.
Correct.
Was there anything unusual going on at your time in your life at that time?
If I remember correctly, that was, and this is one thing that I can attribute it to, if I had to, that was the week that my mom had some, like, I guess we can say a medical complication.
Without disclosing too much, did that require extended treatment?
Follow-ups, yes.
Okay. And did you assist your mom in attending those follow-ups?
I did not go to the follow-ups with her, but I did spend nights with her.
Okay.
Just to be supportive.
And during this time, in March 2018, were you working?
Yes.
And where were you working?
I worked 2 jobs, Aurora Charter Oak Hospital in Covina and Art Counseling and Wellness in Claremont.
Okay. Other than this one missed meeting, have you missed any other AA meetings?
No.
Okay. I would like to talk about your petition for early termination that you filed previously. One of the issues that the board cited in denying that petition was a failure to acknowledge the underlying conduct. Is that correct? Is that
underlying conduct? Yes.
Okay. I believe in your previous petition, you admitted that you did in fact abuse alcohol, correct?
Yes.
However, you were reluctant to say that you were an alcoholic. Is that correct?
Yes.
And has your opinion changed since then?
No.
Okay. And why, well, do you believe that you have some or had some level of dependency on alcohol?
I think during that time, I wish I could explain how this all happened, but in my last hearing, I believe I shared that I was in a toxic relationship with someone who is an alcoholic, and I refrained from drinking because of his behaviors. And so there was a long period of time where I wasn't drinking, and like I've said before, there was definitely times where I didn't control my drinking, and I drank more than I wanted to or should have, and therefore made some unwise decisions.
When you said at that time, do you mean at the time you sustained the DUI conviction?
Yes.
Which DUI conviction?
2011.
Okay. So once again, do you believe that during that time, during the 2011 DUI conviction, did you have some level of dependency on alcohol at that time?
Yes.
Okay. And is there, in your opinion, a distinction between dependency and addiction or being an alcoholic?
Well, I guess I'm focused more on like the criteria for abuse and dependence, and I can definitely say that I abused alcohol, but I don't want to say that it got to the point where I was dependent on alcohol, and this is just based on, for example, criteria from the DSM and even just my own knowledge of dependence and experience with people who have dependence.
Okay. And then what about in 2003? What do you attribute your DUI conviction? What was going on in your life during that time?
I'm sorry, I'm not understanding.
So we talked about 2011, you had a toxic relationship.
Oh, yes,
And
sorry about that.
What, if anything, was happening in your life during the 2003 DUI conviction?
My
Let me rephrase
current-
that you can attribute to the DUI conviction.
Nothing, other than I went out and had not planned on driving home after going out, and I wanted to go home and got in the car and drove home, and I got pulled over for speeding, and then that's when the CHP officer realized that I had been drinking. But I don't want to blame anything. There were definitely things going on in my life. That was the year, I believe, that my grandmother was diagnosed with breast cancer, but I don't want to say that that was the reason why this DUI actually happened. It was definitely my negligence in making that decision to drink and drive.
Okay. And you were in your early 20s during the 2003 conviction?
Yes, 23.
Okay, in 2011 you were 31?
31.
Okay. Now, one of the issues that the board had, that the board cited in denying your previous petition was that you did not have a sponsor for AA. Is that correct during, that at the time of your 2017 application or petition, you did not have a sponsor?
I actually don't remember reading that.
Okay. Do you have a sponsor now?
I do not.
Okay, and is there a reason why you don't have a sponsor?
No. I can't say that there is a reason.
Okay. Have you finished the 12 steps?
No. I haven't been actively working the 12 steps, although there's a sponsor and there's a co-sponsor. And I guess the person that I communicate with would be like an unofficial co-sponsor. And this gal who I've been working with and chatting with pretty much and just processing has been more for guidance than it has been as a role of a sponsor, which I actually asked her if she would write me a character letter to provide for the board, and she did not feel comfortable with that. Then when she decided she was going to do it, she actually was very ill and had pneumonia and didn't get around to writing me the letter to submit on time with my application. But her and I have just been going through the steps, but not necessarily me working the steps.
Okay. Have you ever started or attempted to start the steps?
Yes, they offer essentially what would be like a workshop, and I've attended that, and the one that I actually attended was a women's only one, and I was able to connect with a few women, but unfortunately because of my work schedule, that's not one that I can go to regularly.
Is there, it seems like there may be some reluctance on your part to fully commit to AA. Is that fair to say?
Oh, no. I mean, like I said, AA has been very helpful and opened my eyes to a lot. It's just, I try to go to the same meeting regularly, but the one with the, for the steps is on, I believe, Wednesdays, and that's not one that I can attend because I work both jobs that's on Wednesdays and Thursdays.
Okay. It's my understanding that some people don't or have a hard time connecting with the philosophy of AA, and they seek other forms of group therapy. Is that an issue that you may have, that the philosophy may not comport with your own?
No, actually, I feel that the philosophy with AA is very relatable. I connect with many people there, and even just sharing stories, listening to stories helps me understand a lot more about myself and, you know, the role that alcohol played in my life as well. And I know that sometimes people struggle with the idea of the higher power, but that's actually never been anything that I've struggled with. I have been able to embrace it and feel comfortable with it. Sorry, can I add something?
Oh, please.
Also, I have an individual therapist that I work with, and we do talk about, you know, alcohol and and maintaining sobriety as well.
And I was just going to get to that.
Oh.
And you are in compliance with the terms of probation that require you to attend therapy?
Yes.
And how often do you attend therapy now?
Once a month, and pretty much I switch off. If I don't go to a meeting, I see my therapist.
Okay.
As well.
And during therapy, have you addressed any issue that you have or may have had with alcohol?
Yes.
Okay. Was that a large portion of your therapy?
It has been.
Okay. And do you still continue to discuss those issues?
Yes.
Okay. Do you plan to continue with a therapist if your or when your probation is terminated?
Yes.
And do you plan to continue with AA when your probation is terminated?
Yes.
Okay. And you have a plan in place in the off chance or the if there's a relapse?
Oh, yes, absolutely.
And what is that?
Reaching out to my support system, definitely reaching out to people in AA, and I have a friend who is actually new to recovery, and she's actually been a great source of support and help, someone that I chat with on a weekly basis, which has actually been nice to do that with someone that I've known for about 30 years now.
Okay.
Yeah.
And then going back to the prior petition, there was an issue with that you did not fully acknowledge the significance of the high blood alcohol content from your DUIs. Do you understand why your 2003 blood alcohol content was significant because it was twice the legal limit?
In 2003?
Yes. It was a 0.15.
Okay. And I'm sorry, what was your question?
Why is that significant?
Oh, well, I mean, it's twice the legal limit, but the fact that it was high, that I wasn't sound enough to make safe decisions.
And then in 2011, you had a 0.23. And why was that significant?
Same reason again for not making sound decisions, and with both really putting myself and others in harm's way.
If you can recall, during those two incidents, did you know that you consumed alcohol in excess? If you can recall, I know it was a long time ago.
Yeah. I definitely know that I shouldn't have been driving. I can't think much of 2003, but in 2011, definitely, I know that it had been a long night that I was out, meaning from dinner time until that time that I decided to drive.
Okay. And when your probation is terminated, will you continue with your sobriety?
Yes,
Okay.
definitely.
I have nothing else.
Thank you very much, Mr. Bill. And let's start with board members. Again, arbitrarily, I'll say from my right.
Thank you. Good afternoon, Dr. Reyes. I have no questions. Thank you.
Thank you.
Thanks for coming, Dr. Reyes. I have a couple
Thank
of
you.
questions for
Sure.
you. A couple of times you made the comment, and I think I heard you correctly, I have no commitment when you were talking about AA. What do you mean by that?
So in AA, there's commitments, meaning you can be the chair and you lead the group on a weekly basis or regular basis, rather. Sometimes there are a few times a day. Or you're the one that gives the chips, for sobriety. You're the one that's designated to clean up and things of that nature. And the reason why I don't have a commitment is because I can't commit to going to the same meeting all the time, although I do try to stay within, whether it's that day, because they do offer them different times. But I guess I give myself an unofficial commitment when I do stay and, put books away and fix chairs, really, that's all. And maybe if you want to count the cookies.
Okay. So let me ask, how do you see your relationship to alcohol now?
Now I feel like I don't have a relationship with alcohol, nor do I want one. But definitely the relationship that I did have with alcohol was a toxic one. I don't think I used alcohol in a way to relieve from anything. But like I said earlier, it was definitely very much highlighted and related to my social circle. How I chose to involve myself around certain people, certain situations. And, again, this was my decision, but that's something that I guess then I didn't see it as a red flag, because in my head, everybody was doing it. And now I come to realize that that was obviously not healthy, safe in any way, meaning both physically, mentally, maybe even emotionally, but definitely see that not drinking and being sober is much, much better than when I was drinking, and not just from my personal experience, but seeing it in friends that I do have that do still drink. And I'm no one to judge. Everybody lives their life the way they want to live it. So while I still do have friends that drink often, I don't surround myself around these individuals. It's more, texting and phone calls than it is being there with this person. So that's how it's changed for me. And really my outlook is completely different from when it was, both in 2003 or maybe even just prior to 2011 when I got the last DUI.
Okay, and I think I have one more question. Are you a psych assistant now?
Yes.
Okay, and where are you in your process of moving toward licensure?
That question always gives me a stomachache. I applied to take the exam, and I took the exam in March 2017, and I failed. Unfortunately, I waited too long and the time has lapsed, so now I have to reapply for that registration application for the EPPP again. So I'm hoping to get that all done. I tried doing it yesterday, but for some reason I couldn't do it, and I'm hoping to get it take the exam by the end of May.
Okay, so you have your hours?
Yes,
I'm just
all done.
Okay.
Yes.
Okay, great. All right, thanks, that's it.
Thank you.
Good morning, Dr. Reyes.
Good morning.
Couple questions on my end as well. So you mentioned that your work schedule, you are working 2 jobs right now, and that has been an obstacle in attending certain meetings. Is that correct?
Yes.
And I believe I read in the documents that part of the desire to end termination is so that you can find employment in one location. Is that correct?
Yeah, I'm working 2 jobs just because private practice for me has been a little difficult as far as, like maintaining clients. We work with a lot of students at that office, so we have, they're very bright folks, so they're very much dedicated to their studies where, going to therapy kind of takes the back seat. And also a lot of them graduate, so that's why it's been a little bit hard. But the other job that I do have is, I consider it like my full-time 9 to 5. And so that's one of the reasons why it's been a little difficult. But ideally, I would love to just get licensed and then work at one place just doing private practice. So my degree is in forensic psychology, so I would like to move in that direction.
Great. And would the idea be that if the board granted early termination, that you would see yourself having opportunities to attend maybe one meeting more consistently, or attending or potentially having commitments?
Oh, absolutely. I would love to have that responsibility. And honestly, I think that the fact that they have let me co-chair some of these meetings, well, not some, just 2, I think it's great, and really I've spoken to, turns out that one of the gentlemen that is in AA is someone that I knew from high school, and him and I have been able to connect, and we talk about anonymity in there, so he's actually probably the perfect person to come across in AA, because he has been able to kind of guide me and share with me. He said, one time he was talking about his cravings and how he really struggles with staying sober. And he said there was a time where I wasn't coming to meetings, and I noticed myself feeling anxious, feeling restless and irritable. And he said, and then I took a commitment, and now I feel better. I feel like obviously I'm of service to others and helping others in maintaining their sobriety. So that's definitely a way that I would want to move forward, so that I can also continue to work on my sobriety and be of service to other people who are struggling with their own, issues with alcohol.
And do you feel, given the current constraints you have work-wise, that the cookies and the co-chairing of the meetings sort of is your way to be more involved, but recognizing that there's some time constraints?
Yeah, I consider it more of a contribution. And it makes me feel good that I'm actually doing something for the people in the rooms, which also helps me.
And one final question. I read in your written statement a lot of reasons why you should be granted early termination, and that you will maintain your sobriety. I'm curious, why do you think we are so interested in you maintaining your sobriety?
Obviously to practice safely and be able to help the community in a clear-headed way, and definitely not to cause more harm. because I have been studying for my exam, I feel like I know ethics like the back of my hand now, and I think that's one of the main reasons, because, we're not supposed to cause harm to our clients, and obviously to maintain the safety of the community and the people that I'm working with.
Thank you for your time, Dr. Reyes.
Good afternoon, Dr. Reyes.
Good afternoon.
I just have a couple quick questions. So you attend AA meetings relatively regularly. How do you identify yourself in those meetings?
I just say my name. I asked how they want me to identify, and you just, hi, I'm Amy.
So most people are saying, I'm so-and-so, I'm an alcoholic?
Yeah, there's a few people that don't identify as alcoholics, and then there's some that do.
Okay. So part of maybe the impetus in you initially going to a 12-step program came out of the fact it was a condition of your probation?
Yes.
Okay. What motivation do you have to continue to attend AA if you're no longer under probation?
Well, first of all, because I have acknowledged that alcohol has played a negative role in my life, and most of the folks in there have shared similar stories, whether it was being in jail, hospitalized, suicidal even, lost family, lost significant others, or what have you. Although some of those are relatable, I lost a lot having these 2 DUIs and excuse me, being on probation. So my commitment to continuing AA is for that same reason, that I want to make sure that I stay in this straight line and not excuse me, and not create problems for myself that really I feel are unnecessary. I just want to make sure that there's maintenance, and that's what I want to continue to do. And to be very transparent here, I enjoy going to AA. This community is just so welcoming, so honest, where sometimes it feels like a form of therapy being there and listening to other people's stories and really being present for you, kind of feeling what you're feeling. There's a meeting that I go to on Fridays whenever I have the opportunity. It's called the Resentment Hour. Probably one of my favorite ones, and they don't always relate to alcohol. They relate just to literally life experiences. The last one that I went to was about cell phones and how people get ticked off when, we're having lunch together and this other person is on their cell phone, not really paying attention to you. And I'm thinking, wow, this is so relatable, and it has nothing to do with alcohol, but at the same time, we know that the underlying reason why we're all here is because of alcohol. So, sometimes it just kind of takes away from just focusing on how much did you drink, how often did you drink, and things like that, but really kind of connecting it with everyday life and our experiences with everyday life. And so when I say that sometimes it feels like a therapy session, that's what I'm referring to, because you can go in there, say things, and not feel judged, not feel ashamed. People saying like, oh, I got drunk and forgot where my car was or lost my keys, and nobody's, doing this thing. And it's really nice to have that community, in addition to having my therapist and being able to share one-on-one as well.
I'm sorry, just to make sure the record's clear, when Ms. Reyes was referring to doing this thing, she was shaking her finger.
Oh, sorry.
That's okay, I just need to make sure the record where the court reporter is concerned is clear. Thank you. Go ahead, Dr. Phil.
You had mentioned that part of the relief, I guess, you would feel if you got off probation was that you would not have to be reminded on a daily basis that you're an alcoholic, because you have to call in or check the app, I guess.
Yes, and sorry, what I thank you, I'm going to clarify on that. And what I mean by that is my mistakes and the consequences, but also it's anxiety provoking for me when I have to call in every day, and I've shared this with other people, that there's times where I check in 4 or 5 times because I get so worried that I'm going to miss something, especially after missing that AA meeting. I know I'm hard on myself, but even after that happened, I was very disappointed in myself that I missed an AA meeting, because it's not something that I wanted to do. It's not like I said, I'm going to go live life and not go to a meeting. It's almost like saying, I don't care, but that was not the case. And I missed a meeting, and that was not okay with me. And so this is what I speak to as far as being reminded, like, oh yeah, you're in trouble. This is what you need to do, right? So not in the sense that you're in trouble, you have to do these things, including going to AA, because AA, I don't have a problem with it.
So, if I'm understanding you correctly, you would not have a problem being reminded on a daily basis that you have a problematic relationship with alcohol?
No.
Okay.
No.
Thank you.
I have no questions. We'll move to the next board member.
Thank you for being here and sharing your story with us.
Thank you.
I have several questions. In the probation requirements, there was a notation that one of the requirements was that you attend a 6-month treatment program. Is that correct?
No, I think it was just a program, and I believe what happened was that the programs that I did for the legal aspect satisfied the boards. But I did do a program in 2003, or for the arrest in 2003, I did a 3-month program, a DUI program, and then for 2011, it was a year long.
Okay.
Yeah.
So that
and it was weekly.
And can you tell me a little bit, I've heard your reluctance to identify yourself as an alcoholic, and so I'm wondering what you may have experienced or learned during those programs that either led you to not see yourself as an alcoholic, or how did they change your sense of yourself in terms of your relationship with alcohol?
It changed where it was definitely a lot of education and understanding of the effects of alcohol. Excuse me. For example, when I was going to the classes in 2011, the guy leading one of the groups had us wear, I don't know what they're called, but essentially they're goggles. And he had you walk in a straight line, or at least attempt to walk in a straight line. And nobody was walking in a straight line, because they do it where it's almost like you're intoxicated. And that time, it's interesting how I just remember that stands out to me, that I thought, wow, this whole time, even one drink can impair your abilities, right, or your perception of things. And I don't remember what the equivalent alcohol level was when we wore those goggles, but that time I realized, not one drink is safe, and that's definitely something that I have learned, and I know that I don't want to do that ever again. It scares me. It scares me because I think about, not just financially, but the damage that I could have done myself, property, other people, and I am forever grateful that I didn't. And, not that it takes away from appreciating, but also really understanding that at the end of the day, it's not worth it.
Thank you. So can you help me understand what your reluctance is about finding a sponsor?
It hasn't so much been a reluctance. When I spoke with someone about getting a sponsor, the gentleman that I spoke with, I guess I was unofficially asking him if he would, but the gal that I speak with was actually there. She was sitting across the table from us, and he said, "Oh, why don't you meet with her?" And that's the person that I've been connecting with. I actually haven't connected with her since just January when she was ill. I don't know. I haven't even seen her at a meeting, so I don't know if she has been attending meetings or maybe she's just going on a completely different day. Because usually I would see her on Tuesdays.
The 2011 conviction happened while you were in graduate school.
Yes.
How did you manage if you were engaging in problematic drinking, we'll say, during grad school? How do you think that affected what you were doing at your progress and how you experienced graduate school?
I guess it's hard for me to see it that way because my drinking wasn't frequent. I think now that I give myself the time to really think about what my pattern was, if I had a pattern, was that I would drink maybe more of a longer period for the day. Like if I was out, I would drink, for a couple hours versus Friday, Saturday, Sunday, so that wasn't my pattern of drinking. So I don't think that I struggled with my drinking when I was in graduate school. I was working full time. I was doing an internship and I was going to classes. So I actually didn't have time to go out as much as I guess most people would. So it wasn't, I wouldn't say that it was an issue whether it's, interfered with my studies. But when I did get that DUI, I did immediately notify my school because I didn't know if it was going to be an issue for like placement for future internships or possibly the type of internship that I would apply for.
Okay.
Yeah.
Just one last question. You talked about how you, correct me if I'm wrong, please, how you did not see yourself as an alcoholic, that you were reluctant to apply that label to yourself because you have looked at the DSM criteria for abuse and dependence. Can you say anything more about that, please?
That I would say that I definitely at one point abused alcohol. And, given, for example, some of the criteria being, like the withdrawals or missing work or responsibilities, cravings, things of that nature, I didn't experience that. And, I don't want to say I drank once, drove, and got arrested, or twice. I don't want to say that either, but as far as my intake and the frequency, it doesn't necessarily translate to dependence, but I can definitely say that it translates to abuse, or that it translated to abuse.
Oh, okay, sorry. I just have one more question.
Yeah,
had anybody said to you that they thought you had a problem with alcohol prior to any arrests or after?
Well, maybe my parents, because they were upset, that I actually did drink, but no.
Okay, thank you so much.
No questions?
All right, as I promised, I'm going to see if any board members have any further questions, may have been prompted by something after they asked theirs, so I'll ask for a show of hands. Any other board member questions? And Dr. Reyes, as I also promised, I'll give you the opportunity for further statement if you'd like, and then we'll go through another round if anyone else has questions. Is there anything else that you'd feel you'd like the board members to be aware of in reviewing your petition today?
I can't think of anything off the top of my head now, but I'm sure later tonight I will.
I was about to say
give myself more time.
But
I do want to clarify, just to answer your question, as far as if anyone has ever told me that I have a problem with alcohol, I just want to clarify that my parents said that just because they would just hope that none of their kids drink, and that's the reason why I said that.
Thank you. Let's go back and see if Mr. Bill has any follow-up questions.
No, Your Honor.
All right. And any board members, one last chance? Going on? All right, I don't see any hands. Mr. Bill, anything else that you want to add? Do you want to make a closing statement?
Just very briefly.
All right. And Dr. Reyes, we'll give you the opportunity for a closing statement. There's some technical differences between closing statements and testimony, but let's hear what Mr. Bill has, and then if there's anything else that you want to add, you'll have the opportunity. Okay. All right. Go ahead, Mr. Bill.
Thank you. Case law has provided several interpretations or methods of establishing rehabilitation. On the one hand, rehabilitation is a state of mind, and that was Pacheco versus State Bar. In this case, the previous petition for early termination was denied because of Dr. Reyes's refusal or failure to fully accept responsibility. One of the issues or one of the facts noted in the decision was that Dr. Reyes failed or did not identify herself as an alcoholic. Again, today, she was consistent with that belief. However, she did say that she had some level of abuse, and that her interpretation of whether or not she had a problem with alcohol was more clinical rather than common definition. On the other hand, another method of proving rehabilitation is if a petitioner can demonstrate by sustained conduct over an extended period of time that she's rehabilitated and fit to practice. Here, other than one missed AA meeting over the course of several years, Dr. Reyes has complied with all terms and conditions of probation. I think on balance, based upon her testimony today, I would say that Dr. Reyes has established that she has the state of mind sufficient to establish rehabilitation, and her performance certainly establishes rehabilitation. And because of that, I believe that Dr. Reyes has established her burden.
All right. Thank you very much, Mr. Bill. Dr. Reyes, again, there's differences between closing argument. It's usually what does the evidence that's been presented support in the way of an outcome. You're not required to make a closing argument. You're free to make one. If you do make a closing argument, if it includes any new information, I'll wind up asking if anyone has any further questions for you. That being said, please turn on your microphone.
I turned it off.
Thank you. Is there any additional comment or closing statements that you'd like to make at this time?
Sorta, I guess.
Go ahead.
As far as the rehabilitation, I don't want to say that this is part of my rehabilitation, but like I said, giving back to the community has been very important to me, where I'm staying active, trying to be a little bit more hands-on with that, but I think I mentioned in my statement that I like to do 5Ks and hopefully 10Ks. I've only done one, and it was tough. But, that's definitely something that I do want to continue doing. I actually have one that I'm doing in 2 weeks. And this is also another way of including my family and friends so that I can spend more time with the people in my social circle, but especially the people who I feel are healthy for me. And then at the same time, I'm spending time with them and giving back to the community. So that's one of the, a different way in which I feel that I could be very present for myself, my sobriety as well, and, providing for others as well.
Thank you, Dr. Reyes. Mr. Bill, any follow-up?
No, Your Honor.
Any board members have any follow-up with Dr. Reyes? I don't see any. So at this point, Dr. Reyes, I want to thank you very much for coming here today, participating in the hearing, and supporting your petition with additional testimony. Mr. Bill, very much appreciate your efforts at creating a clear and appropriate record and your recommendations as well. And at this juncture, we'll consider the record to be closed, and we will go off the record.
And we are going to take a lunch break until the next petition hearing, which is set for 1:30. So we'll be back here at 1:30.
And I'll remind both Ms. Reyes and Mr. Bill.
We'll now reconvene the meeting, and I turn the matter again over to the judge.
Good afternoon. Thank you. Thank you. All right, we are opening the record. This is in the matter of the petition for termination of terms and conditions of Chelsea Spitzy. The Office of Administrative Hearings, file number is 2019-030-504. It is April 25, 2019, and this is a meeting of the Board of Psychology taking place at the Los Angeles Hilton Hotel. And I'm going to start with some, bear with me for a moment. Actually, I'll start by asking the president of the board to assure that we have a quorum to go forward.
Is Ms. Burns available to take the roll? Ms. Zorick?
Thank you.
Bernal?
Here.
Horn?
Here.
Fu?
Present.
Phillips?
Here.
Harpsheets?
Here.
Tate?
Here.
All right, it appears that we have a quorum and the quorum and the board is capable of going forward with the hearing. I want to take a few moments to explain some aspects of the process. These will cover the same information that was covered in our petition hearing this morning, but because each of these is an independent record that's being made, I want to make sure that each record shows that we've covered this material. I had previously asked if there were any board members who had not been through a reinstatement hearing, and there were indications there was no one who hadn't been through the process before. I again want to remind board members that they function like jurors, and as such, they should not make a judgment until all of the evidence is in, and that they should base their decision only on the evidence in the record. If any of the board members were involved in prior licensing proceedings relating to the petitioner, you need to, in essence, wipe that slate clean and rely upon the information that's presented on the record here today. I also want to remind board members that they act like judges. They must be fair and impartial and not be biased. On occasion, I've had instances where, for any number of reasons, a board member has indicated they are uncertain or they cannot act in a neutral or unbiased manner, and therefore the potential for recusal exists. Let me ask all board members if any board member believes that they have a basis to recuse themselves from this proceeding. I see no show of hands, so we'll proceed. The order of the proceeding today is that after this brief introduction, actually let me have the representative of the Attorney General's office identify himself for the record.
Good afternoon, Your Honor, and members of the board. Deputy Attorney General Brian Bill on behalf of the Attorney General's office.
Thank you, Mr. Bill. And can I have the petitioner please identify herself for the record?
Hi, I'm Chelsea Spitzy, and I'm here representing myself.
Thank you, Dr. Spitzy. So the order of events, once we are done with this brief introductory matters, is that Mr. Bill may have a presentation of evidence. I believe he's given you a notebook, and all of the board members have the materials. There's a process where Mr. Bill will ask for each item in the notebook to be marked for identification. That's just a formal process for me to assign a number to the document. At some point, he's likely to ask for the documents to be received in evidence, and that means that the board members are then able to use the information, to use the documents as part of their decision-making process. And Dr. Spitzy, if you have any objection to any particular document, I'll give you the chance to let me know and let the board members know, and then a decision can be made about whether the document can be used or not.
Thank you.
I want to remind board members that they must be present through the entirety of the hearing to be able to vote on the petition during executive session. If you feel the need to make a phone call or if you need a bathroom break, let me know. We can take a recess so that we don't proceed in your absence. I'll also ask for everyone's continued attention by not referring to text messaging or social media or any other outside influences that are not relevant to the proceeding while we're in the hearing. All right, and again, to explain in a little more detail, Ms. Spitzy, once it's time for you to make your presentation, I will swear you in. You can then give the board members the information that you believe is important. Once you're finished with your statement, I'll ask Mr. Bill if he has any questions for you, and then I'll give board members the opportunity to ask questions. And then I'll come back to you and see if there's anything that you may want to add. Some other additional information may have come to mind, and we'll go through that same follow-up process. Mr. Bill has a chance to ask questions, and then board members may have the chance to ask questions as well. Let me ask at this point, Dr. Spitzy, are there any questions you have about the process, either about anything I've said or anything else that I might be able to answer for you at this time?
Not at this time.
All right. If a question comes up during the hearing, please ask. Excuse me, Judge, I'm not quite sure what that means or what the effect of that is, and I'll do the best I can to explain. All right. Okay. Mr. Bill, you may proceed.
Your Honor, before we begin, I would like to put something on the record, and I did discuss this issue with Dr. Spitzy last week out of a courtesy, since she's not represented by an attorney. I don't believe that this board has the authority to grant the requested relief. I believe that the type of license that was granted to Dr. Spitzy does not allow for relief under 2962. So I would object to having this hearing in the first place, and then certainly object to the board having the ability to grant the request. I know there's no vehicle for a motion to dismiss in APA proceedings, so the hearing will go forward, and I think in this case it's a good idea that Ms. Spitzy explained to the board why she believes she's entitled to the relief. Thank you.
All right. If I may ask for some further clarification, in your comment about lack of authority, you referenced that being based on the type of license. Could you be more specific?
Yes. Dr. Spitzy was granted a conditional license with terms and conditions. In the decision and order by the board correctly distinguished between a license where it's initially granted and then immediately revoked, stayed, and then placed on probation. Dr. Spitzy's license was granted in a different way. She was granted a conditional license, which will vest upon the completion, the successful completion of the terms and conditions. In the probationary license context or example, all the benefits and protections vest when the license is granted. And that's granted upon the order of the court and the board. In this case, the license was not granted. It will be granted and it will vest upon the successful completion. And at that point, the benefits and the protections afforded by the Business and Professions Code will apply. I'll have more to say about that, but
All right.
that's
Thank you
my
for answering
position.
the question. At this juncture, as you mentioned, Mr. Bill, you're not referring to any statutory authority in the Administrative Procedure Act for a motion to dismiss. If I consider your comments as being an objection to the board going forward with the hearing based upon the claim that it lacks authority, I'm going to take that objection under submission. Some of the reasons, and without being exhaustive or all-inclusive, the objection is based in part on the development of at least a partial factual record. The nature of the existing license, the conditional license, as you refer to it, is a fact, and the board members, or an alleged fact, I should say, I don't think there's much controversy about it. However, the board, as I mentioned a few moments ago, acts as jurors, and part of that responsibility is to determine the facts in the case. So I think that it is necessary for the board to go forward with the hearing with the nature of your comments in mind to be discussed and determined during executive session. Be happy to entertain further argument about this if you intend to make it in closing, or give you the chance to make further argument on it now if you choose.
Well, you raise good points and they're well taken. To answer your point, I would ask that the board and Your Honor that you take official notice of board case number 600-2015-000498, the decision after rejection, dated, I believe it's dated July 26, 2016, with an effective date of August 25th, 2016.
All right.
But once again, I'm not aware of any vehicle that allows for a dismissal of a case. So I just wanted to put that on the record, that
All right.
the initial objection.
Technically, a request for official notice requires input from both parties. I'm going to try and save us some time here. I think it would be an inefficient use of our time for me to explain to Dr. Spitzy what the nature of official notice is generally and what the effect may be specifically in these proceedings, and then seek her input. In the alternative, we will take your request for official notice under submission as well.
Fair enough.
And that being said, you may proceed.
Thank you. Can I mark for identification the documents?
Go right ahead.
Thank you. I would like to mark for identification Exhibit Number 1, the Petition for Early Termination of Probation packet. And that's AGO 0001 through AGO 0203.
Thank you. And the documents described by Mr. Bill will be marked for identification as Exhibit 1 to these proceedings. Mr. Bill, do you intend to request that each of these documents be moved into evidence during the course of the hearing?
Yes, Your Honor.
All right. So let me explain the process, Dr. Spitzy. Again, the first step, marking a document for identification, is pretty mechanical. It's just to make sure the record is clear about exactly what's happening, what document is which. And you should have a notebook in front of you where all of these documents have been tabbed, and there's a list at the beginning, an exhibit list that hopefully will help guide you through. As I mentioned a few minutes ago, you do have the right to object. Of course, many of these documents are things that you've submitted to the board, but I will be asking you for each one, if you have any objection to the board being able to use the document during the hearing or during its deliberations. So we'll start here with what's been marked as Exhibit 1 for identification. Do you have any objection to this being used? No. Thank you. So Exhibit 1 will be received in evidence. Go ahead, Mr.
Your Honor, I'd like to mark as Exhibit 2 the notice of hearing and proof of service, as well as the request to set.
The documents described by Mr. Bill are marked for identification as Exhibit 2 to these proceedings. I'll note, hold on, that this includes a page of guidelines for argument that were sent to Dr. Spitzy and give some instruction about the process we're going through today. Dr. Spitzy, any objection to the board considering Exhibit 2 during the hearing?
No.
Thank you. Exhibit 2 is received in evidence. Go ahead, sir.
Your Honor, I'd like to mark for identification Exhibit 3, the Certificate of Licensure.
The document described by Mr. Bill is marked for identification as Exhibit 3 to the petition. Dr. Spitzy, any objection to this being used?
No.
Thank you. Exhibit 3 is received in evidence. Go ahead.
I would like to mark for Exhibit 4, the decision after rejection, AGO 0211 through AGO 0221. Let me rephrase that, Your Honor. It's a certified copy of the decision after rejection.
Thank you. The document described by Mr. Bill is marked for identification as Exhibit 4 to these proceedings. And Dr. Spitzy, any objection to this document being used?
No.
Thank you. Exhibit 4 is received. Go ahead, Mr. Bill.
Your Honor, I would like to mark for identification Exhibit 5, the notice of rejection of proposed decision, the order setting date for submission of written argument and stay of decision, as well as the proposed decision. It's AGO 0222 through AGO 0242.
Thank you. The documents described by Mr. Bill are marked for identification as Exhibit 5 to these proceedings. Dr. Spitzy, any objection to this?
No.
Thank you. Exhibit 5 is received in evidence. Go ahead.
I would like to mark for Exhibit 6, the terms and conditions report.
The document described by Mr. Bill is marked for identification as Exhibit 6 to these proceedings. And Dr. Spitzy, any objection?
No.
Thank you. Exhibit 6 is received in evidence. Go ahead.
I would like to mark for identification Exhibit 7, the probation profile.
The documents described by Mr. Bill are marked for identification as Exhibit 7 to these proceedings. Dr. Spitzy, any objection to these?
No.
Thank you. Exhibit 7 is received in evidence. Go ahead.
I would like to mark for identification Exhibit 8, the correspondence documents, AGO 0250 through AGO 0293.
The documents described by Mr. Bill are marked for identification as Exhibit 8 to these proceedings. And Dr. Spitzy, any objection to these?
No.
Thank you. Exhibit 8 is received. Go ahead, Mr. Bill.
I would like to mark for identification Exhibit 9, the intake forms, AGO 0294 through AGO 0299.
The documents described by Mr. Bill are marked for identification as Exhibit 9 to these proceedings. Dr. Spitzy, any objection to these?
No.
All right, hold on just for a moment. Exhibit 9 will be received. In a quick page through, I noticed that there was a copy of Dr. Spitzy's driver's license that includes her driver's license number. I would normally consider that to be privileged or confidential matter, and unless there's a need to have it in the document, in which case it can be sealed, the other alternative is to redact it by marking it out with a marker. So actually, I'll ask for input if any board members feel it's necessary for a driver's license number to remain visible in the exhibit. I see no indication that it should. Mr. Bill, do you feel that this should be sealed as opposed to redacted?
Your Honor, I believe that should have been removed, so I would just ask that you remove this page.
Okay.
And it not be considered.
Okay. Well, as I page through this, again, I haven't seen many of the well, I've looked through them very, very briefly, but I see, in addition to the driver's license on page 299, on page 297, there's a handwritten driver's license number as well. I don't know if, again, maybe it's just easier to seal these pages so that they remain available but not open to the public. Is that okay with you, Mr. Bill?
If you'd like to seal it, that's fine. If you
It's really
want to
more what the
redact it-
parties ask for as opposed to what I would like. If you'd prefer to remove them, they can be removed. If you ask me to seal them, I think they should be sealed. So I think that
I'll leave it.
I mean, I would just be concerned if my patients can get a hold of that information and then come find me.
all right. Well, that raises other issues.
And Your Honor, just briefly.
Yeah.
I did provide the board with a redacted copy of all the binders for each hearing today and yesterday.
I see.
That will be available to the public, should there be a petition for record or
All right.
Public Records Act request.
I don't want to get too technical and get too lost in the, in the weeds on this. What I am marking and potentially receiving in evidence is the evidence being used at the hearing, and I believe that although I appreciate the fact that redactions were made, I don't know that a redacted copy can be substituted as opposed to redacting the actual documents that are being marked and received in evidence, either redacting them or sealing them. I'm going to make the following suggestion. I think that some further discussion and maybe input from counsel for the board during executive session might help resolve this, and I can put the outcome of that discussion in the decision. But I think the options are either sealing of certain documents or removing them. I'm concerned, based upon the comment that Dr. Spitzy made, that her address is everywhere throughout these documents. And again, these are the documents that, by my understanding, become the publicly available documents. I do not want protected, privileged, or confidential information to be disclosed inadvertently because I haven't taken the proper measures to make sure that doesn't happen. So the best I can say at this point is we'll have further discussion about this during executive session. I will indicate in the decision I will draft on behalf of the board what the outcome of that discussion is. If it turns out that documents are going to be sealed, my office has a process of issuing a separate written protective order relating to documents that are sealed. So if that's the outcome of the process, then a written order may issue separately as well.
Your Honor, I can make it a lot easier for the board
Please.
and the court. I would stipulate to any sealing of any record that has any private information or any information that discloses the petitioner's address or telephone number.
Okay, thank you. And am I correct, Dr. Spitzy, that is also your concern that things such as your address, phone number, driver's license number, social security number, if it's found in these documents, should also not be made available to the public?
Yes, I work in a forensic setting, and it would concern me.
All right. Again, I think that further input from the board's counsel, who I know is present and will be present during executive session, might be helpful as well. So we'll work through the issue. And again, there'll be some indication of what the outcome is. Great. Thank you very much. All right. With that being said, Exhibit 9 is received. And I want to be clear that prior exhibits that may contain the same type of information might be affected, and there may be changes to the manner in which they're handled, meaning they may be sealed or redacted. We'll see. All right.
I think that's
Thank
appropriate,
you.
Your Honor.
All right. Go ahead, Mr. Bill.
I would like to mark for identification Exhibit 10, the chronological record.
The document described by Mr. Bill is marked for identification as Exhibit 10 to these proceedings. And Dr. Spitzy, any objection to this?
No.
Thank you. Exhibit 10 is received. Go ahead, sir.
Your Honor, I'd like to mark as Exhibit 11 the drug screens. And I would ask that these documents be sealed.
All right. The documents described by Mr. Bill are marked for identification as Exhibit 11 to these proceedings. Dr. Spitzy, any objection?
No.
All right. Exhibit 11 will be received in evidence. Go ahead, sir.
I would ask that the court mark as Exhibit 12 the courses taken by Dr. Spitzy.
The documents described by Mr. Bill are marked for identification as Exhibit 12 to these proceedings. Any objection, Dr. Spitzy?
No.
Thank you. Exhibit 12 is received in evidence. Go ahead, sir.
Your Honor, I would like to mark as Exhibit 13 a document that is titled Violation of Terms and Conditions.
The documents described by Mr. Bill are marked for identification as Exhibit 13 to these proceedings. And Dr. Spitzing, any objection to these?
Yes.
And what's the objection?
The objection is that that test with the alleged violation was against the conditions that I signed with the board because the test went into the tolling period where I was on maternity leave and not subject to the conditions. My license was...
I'm going to stop you for the following reason.
Okay.
My concern is
think it's
this,
inadmissible.
Doctor, my concern is this, that the information you're giving is information that technically should be while you're under oath.
Okay.
So I'll note that you have an objection. I'll note that we need to cover the basis of that objection once you've been placed under oath, and then a determination can be made
Sure.
whether or not Exhibit 13 will be received in evidence.
Okay.
All right, thank you. And Mr. Bill, I'll give you the opportunity, obviously, once Dr. Spitzy has given her testimony about that, if there's either questions or some additional argument you want to make with respect to Exhibit 13, you'll have the chance to do that.
Thank you, Your Honor.
All right. And Mr. Bill, any other documentary evidence that you want to present?
No, Your Honor.
All right, thank you. Is there an opening statement that you wish to make, Mr.
Just very briefly, Your Honor.
Go right ahead.
As I stated in my objection, the issue in this case is one of availability of relief. I do not believe that the requested relief under Business and Professions Code 2962 is available to Dr. Spitzy based upon the type of license that was issued by the board. This case should not be decided on the merits, but I will say that it appears that Dr. Spitzy is generally in compliance with the terms and conditions, and it appears from the record that she is dedicated to the practice of psychology. Once again, the issue is whether or not the law allows the board to grant her relief.
And I want to be clear, Mr. Bill, I think it's appropriate under the circumstances to be clear that I won't consider it as a waiver for you to engage in discussion of specific evidence that you might not otherwise do for fear of waiving the objection that you've raised. I don't consider that to be appropriate or fair process to the people of the state and the basis on which you are here representing the people. So appreciate your input. You may continue.
Your Honor, that's all I have.
All right. Thank you. All right, Dr. Spitzy, at this point, we're ready to take your testimony. So what I'm going to do is ask that you stand and raise your right hand so that I can swear you in. Do you solemnly swear or affirm that the testimony you'll give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please have a seat. Please state and spell your name for the record.
Chelsea Spitzy, Chelsea. Last name Spitze.
Thank you, Dr. Spitzy. A few things to keep in mind. It's very common for people to be nervous. I think we all understand that. Sometimes when people are nervous, they may speak quickly, so we may ask you to slow down. Sometimes the volume drops. We may ask you to keep your voice up. Also keep in mind that Mr. Bill has the right to raise objection to your testimony. If you hear him say objection, I want you to stop your testimony. I will determine the nature of the objection and then give you instructions on how you can proceed. Once you've finished with your testimony, Mr. Bill may have questions, board members may have questions. I will then come back to you, allow you to provide any additional information, and we'll go through any further questioning. Let me ask, before you go into your narrative, if there are any additional materials that you wanted the board to consider.
Yes, there are.
All right. Let me ask a little bit of information about what it is you have. Do you have copies that are for each of the board members to consider?
I did make copies for each
All
of
right.
them, yes.
And is there a single type of document, or are there multiple types of documents that are contained in this additional submission?
So there's multiple types of documents. Yeah.
All right.
Multiple.
Have you provided these to Mr. Bill before today?
I did, yes.
Okay.
And I also printed them for you.
Thank you.
Okay. Am I correct, though, that this will be the first time that the board members will be seeing them?
Some of them, yes. Some of them
Okay.
I just didn't submit with my application.
All right.
But I think they're relevant.
What I'm going to do is come over and ask you for your sets that you would like the board members to have. I'll then distribute them, and then we can proceed with your testimony.
Are there 9?
Thank you. Dr. Spitzy, I'll hold on to the rest just for the time being. I may return these to you before the end of the
Yeah.
And let me just ask a point of order of the president. Would you like to take a few moments of recess for board members to quickly review, or would you like the doctor to proceed with her testimony?
Why don't we proceed with the testimony unless other board members feel to the contrary?
All right. If any board member feels that they'd like to take a recess at some point before further questioning, we can certainly consider that as well. All right. Doctor, you may go ahead with your testimony.
Okay. So first of all, good afternoon, everybody. I'm Chelsea Spitzy, and I wanted to thank you guys all for being, sorry, I hope I don't cry too often in this. Okay. Clearly, this has been an emotional process for me, but I just wanted to thank you guys for being here today to listen to the evidence of my rehabilitation. I was going to say, as you may have seen, my husband was in here to support me, but I think he had to take our son out. If they come back in, he'll be good about taking him out if he's crying or talking. All right, so before I get started with and I'm going to be reading a lot too. Before I get started with the substance of my testimony, I wanted to make it known and to submit into record. This is something that the board may have seen before, but thank you. The 2 certified copies of my expunged record. So prior to getting a license, I had met in front of the 2 separate judges in the counties where I had had the criminal convictions and presented to them evidence of my rehabilitation, and they had decided that it was appropriate to expunge my record or dismiss those charges. So I wanted to submit that or make it known that my record is expunged.
And Your Honor, I'm sorry, I'm going to object to that. That's, 1, it's a legal conclusion, and 2, it's not supported by the documents she's submitting.
All right, at this juncture, sorry. I'm going to overrule the objection without prejudice. I'll allow Dr. Spitzy to continue to make reference the objection may go to the weight as opposed to the admissibility of the comments. And if I'm not, and I won't permit the board members to receive those as legal conclusions. Dr. Spitzy is not a legally qualified expert as far as I know. So the objections are overruled. Go ahead, Doctor.
Okay, thank you. Next, I was going to talk about how it was brought to my attention about the eligibility of whether I'm eligible for early termination because my license is called conditional and not probationary. I did, however, over a year ago, have a discussion with the probation monitor with the board, Mr. Curtis Gardner, who also told me he spoke with his supervisor who indicated that I could apply.
I'm going to object to hearsay, Your Honor.
All right. I'm going to sustain that objection and let me explain. Dr. Spitzy's statements that are made outside of the hearing that are submitted for the truth are hearsay. However, in these proceedings, we're allowed to rely upon hearsay, but in a limited fashion. It's colloquially referred to as administrative hearsay. The reference is Government Code Section 11513, Subdivision D. So administrative hearsay can be received. It cannot by itself be the basis of a factual finding, but it can be used to supplement or explain other evidence. I realize that may sound like some legal gobbledygook, but it does have some significance. Even though I've sustained the objection, the references will remain on the record because they are administrative hearsay and might have a limited utility in the board's consideration and decision.
Okay.
Go ahead.
I'm sorry, Your Honor. Can that just be a standing objection so I don't keep interrupting the proceeding? And I ask that just because Dr. Spitzy is unrepresented. And
I understand. I'll permit it, but I'll state for the record what my concern is. By making it a standing objection, you're in essence relying upon me to understand and assert it at the appropriate time. I will not be doing that. I understand your concern about not wanting to continually interrupt Dr. Spitzy, but I can't make an assumption of what it is you're objecting to, what it is you're not objecting to. A further complication is under that same government code section, a hearsay objection can be made at any time. It's not waived if it's not made contemporaneous with the reference. It complicates things tremendously to have a standing objection. Nevertheless, for convenience purposes, I'll permit it if I determine during the course of deliberation that the board members appear to be relying on what is otherwise administrative hearsay for the truth of the matter, I will so advise them.
thank you. And Your Honor, perhaps I should just take notes of the specific statements that I object to and at one time raise those
I think that would be
objections.
helpful so that I don't have to step into the guise of an advocate as opposed to a neutral.
I'd be in good hands if you did, though.
All right. Thank you. Go ahead, Doctor.
Okay. I wrote a letter to Governor Jerry Brown after learning that there may be some question of whether I could apply for early termination, and his office has contacted the Department of Consumer Affairs, who spoke with the Board of Psychology, and the correspondence that I received back, which is included in your packet, said that the board also advised that since you agreed to the terms and conditions of your probationary license, the board cannot reevaluate your restricted license until August 2018. It also did say that you may petition the board for early termination or modification in penalty in August 2018.
All right.
So,
Is this material in this new package that you've just given us or in prior?
yes, it's in the new
All right.
part of it, I think.
It occurs to me I have not yet marked that for identification, so I need to do that. I'm going to mark this new package of information as Exhibit 14 for identification, and I'm simply going to describe it as material submitted to the board on this date.
Okay, and the letter's dated September 22nd, 2017.
Thank you. And Mr. Bill, I will ask you at some later point whether you have any objection. I want to allow Dr. Spitzy to complete her testimony and also to allow you the opportunity for cross-examination. Go ahead.
Okay, so now I'd like to discuss the evidence of my rehabilitation. Okay. I first want the court to know that I truly feel remorse and a substantial amount of shame for having had such poor judgment, placing myself and others in danger. Over the past 7 years, I've had a lot of time to reflect on the decisions the decisions I made and have experienced a lot of personal growth and maturation. In my professional life, I've completed a PhD program, have been employed as a psychologist, and have had the privilege to work alongside respected and knowledgeable professionals for whom I have a lot of respect and have learned a lot.
Doctor, would you like to take a short break?
I think I just need to get through it.
Okay.
I'm also pregnant, so maybe that's making me more emotional. Okay. I have also had the privilege to support many individuals in their process of recovery and growth. Through the years, I have come to realize the level of responsibility I have as a psychologist to maintain my professionalism and to act thoughtfully and with good judgment, no matter what role I'm in. As I wrote in my letter to the board, I strive to maintain a high ethical standard in all that I do, and that this aspiration is not one that will end with the termination of the conditions on my license. For me, having the experience of participating in random and observed tests over 91 times and sharing my story with colleagues and friends has had a deep impact on me. Many times, I was feeling intense shame, and other times using my experience as a way to motivate others to behave in safe and ethical ways. It has taught me that I must always think before I act. The experience has been one that leaves me changed forever. And whether I'm subject to the conditions of my license or not, my commitment to continued personal growth is steadfast. Professionally, I've been making efforts towards applying for the senior psychologist supervisor position at my current place of employment. Included in the packet is the notification that I passed the exam and that I'm now on the list of applicants. The notarized letters, which are also in the new packet, The notarized letters also confirm my intention for this position. However, with the conditions that are on my license that I can't supervise, I would not be able to accept this position. Another significant change in the past 7 years, and probably the most poignant to me, and one of the biggest reasons for my being here today, is my becoming a wife and mother. When it comes to my family, I am inspired and resolute to always act in ways that make me a good partner, and most importantly, a good mother. Sorry, guys. Okay, thank you. Sorry.
On the record. And Dr. Spitzer, you may continue with your testimony.
Thank you, guys. I'm sorry, I'm very emotional when it comes to this. Okay. I want nothing more than to be a good role model to my children and for them to always feel safe. While I've been subject to the conditions of probation, I've had to devote much-needed financial resources as well as time in meeting my obligations. This has meant me having to cancel weekend plans, spend over 2 hours in the car, and sometimes bring my young son to testing, where I've had to hand him to a stranger so that they can watch me pee. This truly pains me and worries me. What is this like for him? What message am I sending him? And how will I do this with a toddler and a newborn? Because of the limited availability of testing sites, I'm also unable to bring my son to his grandparents without being prepared to drive at least an hour each way if I get called in for testing. And now his grandmother will be moving out of the country in May. During my time with the conditional license, I met with Dr. Barry Glenn, a licensed psychologist, to discuss my past behaviors and the conditions of my license. With her, I was able to identify antecedents to my past offenses and to work on ways to prevent such lapses of judgment in the future. I also found our meetings helpful in working on the anxiety I was experiencing related to the difficulties I was having regarding the availability of testing sites and my emotional response to having a stranger watch me pee. Additionally, our meetings gave me the chance to explore more in depth the role that alcohol had played in my life. Dr. Glenn was hoping to come speak on my behalf today, but given the location, she wasn't able to, so she provided me with a notarized letter, which is included in the packet. Since being on the conditions of my license, I have submitted to over 90 random observed tests, which included urine, blood, and hair samples. I've completed over 166 hours of continuing education, which is at least 130 more than required for licensure. Of these hours, more than 48 were focused on substance abuse and recovery, which is 18 more than the required by the conditions of my license. I have over 14 letters of support for the early termination of these conditions from colleagues, family members, and my individual therapist. These individuals are well-respected and licensed medical doctors, psychologists, social workers, and rehabilitation therapists. These are testimony to my character and rehabilitation. It is my hope that these letters, some of which are notarized, the ones I gave to you guys today, can act as testimony on my behalf. By no means am I saying that when I chose to drink and drive, that it's excusable. What I am saying, however, is that those two offenses, they were expunged from my record by 2 judges in 2 separate courthouses. In the entirety of my professional life, through the years of internship to present day, there has never been one complaint against me by a patient or colleague, and I've always been well respected for my work and judgment. The offenses were 7 and 12 years ago. I have gone to therapy, earned a PhD, completed all the requirements for licensure, invested over $400,000 in this career, and have become a wife and mother. In the packet you'll see, I don't know if it's, anyways, it's a copy of my student loan debt. Please consider the growth and maturation that I've had and the further evidence of rehabilitation through the letters of testimony by those who know me best and who interact with me almost daily. Thank you all. That's all I have to say right now.
Thank you, Dr. Spitzy. And Mr. Bill, if you have questions, you may inquire.
Yes, thank you. Thank you for being here, Dr. Spitzy. You might want to turn on your microphone. Just a few questions about the DUIs. The first DUI occurred in, was it 2008?
No, I believe it was 2007.
The conviction was 2008?
I can't even recall.
Okay. The first
It would
incident-
say on the certified copy I submitted of my expunged record.
Sure. The first DUI, how old were you?
23.
You were still in college?
I had just finished college.
Can you tell the board why did you decide to drink and drive?
Yeah, so I had gone to Davis to visit friends, and we had gone out. I had waited what I thought was a while. I was 23. I wanted to actually get back to the Bay Area so that I could study for an exam I had. I had just started graduate school, and I made a poor decision.
At that time, when you were 23 years old, did you drink regularly?
I don't know what regularly means.
Did you drink
but
every weekend?
No.
Once a week?
I don't recall. I mean,
Okay.
it was when I was 23. I was just finished college.
Let me just state this. At that time, when you were 23, did you believe you had a problem with alcohol?
No.
Okay. And then in 2012, you received another DUI conviction, is that correct?
That is correct.
And you were 27, 28?
I believe I was 20, just turned 28. It happened in May 12th, or May 7th, excuse me. So I had just turned 28, I think.
Okay. And at that time, how often did you drink, if you can recall or estimate?
I honestly can't recall, but it wasn't very often.
So is it fair to say that you did not have a problem, or you don't believe you had a problem with your use of alcohol?
I think I had a problem with my use of alcohol because I drank and then I drove. I think that's a problem.
So the problem was limited to these two instances?
The problem was limited to those two instances, if you can believe it or not. And I think when you ask me that question, I think there's a lot of different answers for what I could do now. I mean, we didn't have Uber back then, Lyft. I didn't act with good judgment.
Okay. I want to talk about Exhibit 13. This is a letter that you received from Curtis Gardner, is that correct?
I have to open it up and look.
Oh, sure. It's the very last page.
And this is the exhibit that I object to.
Yes.
Yeah, I recall receiving this letter, trust me.
Okay. Did you receive any citation as a result of the, and I'll use the alleged positive test?
No, I did not.
Okay. And there was no formal filing of a violation of the terms and conditions? There's no formal case heard?
Correct.
Okay. I wanted to just discuss the facts surrounding this test.
Okay.
Let me ask the question. The test was on August 8th,
That's
2018?
Mm-hmm.
And you had recently just activated your license, or reactivated your license, correct?
Correct.
You were on maternity leave for a period of time?
Correct.
And how long was that?
I have it in the packet under testing.
How about this?
Tolling was from April 14th to August 1st, 2018.
Okay. And this positive test, according to the board, tends to indicate that there may have been use of alcohol, correct?
If that's what you're telling me.
Okay.
I'm not going to assume, but
Okay.
yes.
During the period from April to August 1st, 2018, did you consume alcohol?
No, I did not.
Okay. Do you have any explanation for the positive test?
Yes, I do.
Can you explain that to the board?
Yeah, so while I was on tolling, I was not cautious with food and beverages that I consumed. I consumed tiramisu. I had some other desserts that had some traces of alcohol in it. I drink kombucha when I was on tolling. And my understanding now is that kombucha has, or can have, some alcohol in it because it's a fermented tea.
That's the explanation,
Yeah.
okay. So if I understand correctly, while your license was active and you were under the terms and conditions, you did not consume items like tiramisu or kombucha?
Correct. I don't even use hand sanitizer.
And why did you decide to consume these products when you were in your tolling period?
I don't think I was thinking like I'm going to decide to consume them. I think I was thinking, oh, I don't have to be as cautious. And my understanding is that kombucha is good for you. It's good for your metabolism. And that's why I drink the kombucha. The tiramisus and desserts and whatever. I can't honestly recall what I may have consumed over that period of time. I did have a newborn baby and was not sleeping at all. But yeah.
And I'm not asking for a comprehensive
Yeah,
list, just in general.
I don't know.
Okay. And then did you stop drinking the kombucha when your license was reinstated?
Yes.
On August 1st?
Correct.
And you did that consciously?
Mm-hmm.
Okay. Is that a yes?
Yes.
Okay.
I knew before that kombucha could have some traces of alcohol in it. So I stopped drinking it before. Yeah.
Now, after the August 8th test, do you recall taking a test after that
Yes.
at some point?
Mm-hmm.
And do you recall when that date was?
Yeah, I took the test on the 13th.
And was that test negative?
Correct.
Okay, and other than this one allegedly positive test, have you had any other positive tests?
No. And may I also say something here?
Go ahead.
So I also submitted to you guys, after having that alleged positive test and being very caught off guard, I did speak with an attorney, and they told me that I should see if I could get the PET test again. So I went and found a place to get the PET test, and they did the PET test again on me, and it was negative. And I submitted that to you guys as well.
I'm sorry. What was submitted, Dr. Spitzy?
The record of a PET test that I got on my own, outside of the requirements from the board, where the blood draw was done on August the 30th, 2018, and the results were negative.
Okay.
And my understanding is that test covers 30 days at least.
Okay. If I could just have one moment, Your Honor.
Certainly.
And are you in compliance with the remaining terms and conditions of your license?
Absolutely.
Okay. I have nothing else. I have nothing
Thank you,
else.
Mr. Bill. All right, let me ask Dr. Spitzy, when you raised your objection, and I said that we needed to wait until you were under oath, you've now given us some information in support of your objection. Is there any other information you want to provide with respect to your objection to Exhibit 13?
I don't think so. I just want it to be clear that I didn't consume alcohol while I was on maternity leave, and that I did consume kombucha, and that test that I took on August the 8th covers 30 days, which I got my license back August 1st. So it would go well into the tolling period.
And just to be clear, the voluntary PET test that you took on advice of your attorney, the results are in this package we've called now Exhibit 14? Is
Yes.
that correct? All right. So just for technical reasons, I'm going to overrule your objection to 13. I think the points you have raised go to the weight that the board members may give in considering the exhibit, but don't make the exhibit inadmissible.
Okay.
So for the record, Exhibit 13 is received in evidence. And Mr. Bill, I had indicated that we would address Exhibit 14, admissibility. I'm going to defer until all board members have had a chance, until we've gotten as complete a record as possible before I find out from you if there's any objection you have to 14, unless you have no objection at this point.
No, I have objections to specific documents, but
Okay.
Your Honor, I would like to.
We'll hold that in reserve until we've had some further testimony, and then you can tell us what your objections are.
Okay, but can I make an objection to Dr. Spitzy's statement regarding the length of the testing period?
All right.
Lacks foundation, calls for an expert opinion, and.
All right, I'm going to overrule that. It's not being received as an expert opinion, but merely Dr. Spitzy's understanding of the nature of the test and the period of time that it covers. It doesn't hold the same weight as an expert opinion might hold. Okay. Thank you.
May I say something?
Yes, you may.
I did submit to you guys I'm not an expert in this PET test, but I did submit a research article on it as well that says the length of time that it covers, I believe.
Thank you. All right. We'll take questions from board members. This time I'll start on my left with Dr. Tate. Any questions?
I have no questions.
I have no questions.
Good afternoon, Dr. Spitzy. If I understand your testimony correct, you do not consider yourself an alcoholic.
That is correct.
Do you intend to remain abstinent from alcohol after your probationary license is no longer?
I have no intentions to start drinking alcohol. I'm quite busy with the family.
But do you intend to remain abstinent?
At this time, yes.
And what does that mean at this time?
That means I don't plan to drink after
Right
I'm
now.
off, when I'm off.
Do you intend to drink in the future?
I don't have intentions to, no.
Okay, thank you.
Good afternoon, Dr. Spitzy. Let me move closer to the microphone before I get yelled at. So, related to Dr. Phillips' question, what is your plan for continued sobriety?
I mean, I've been able to be sober this whole time with just an intention, because I don't find alcohol to be such a large part of my life. I mean, prior to this, I wasn't drinking often, so it wasn't difficult for me to just abstain.
So, attending AA meetings, for example, would not necessarily be a part of that plan.
I haven't attended AA meetings during this time, and
Right.
that's not a plan.
And with regard to the letter to the governor and the copies of the responses we got, what were you thinking when you sent that letter?
Probably a lot of things. I think one of the things I was thinking was I had been under the conditions for a year at the time that I had met with the probation monitor, and I had been talking about applying for early termination for quite some time, and it wasn't until over a year into my terms that I was told that I wasn't eligible for it. That was one thing that made me write a letter to the governor.
And could you explain, you've mentioned this several times, that the decision to drink and drive was a poor decision or lacked good judgment.
Mm-hmm.
Can you explain why you think that?
One thing, alcohol was more prevalent in my life then. I mean, I'd just gotten out of college. And then I didn't make a good judgment about Uber or Lyft. There was none there available at the time. I actually relied heavily on the judgment of others around me, whom I was out with. And I had actually made mention a couple of times that I didn't think it was a good idea and let's figure something else out. But they encouraged me to do so. So I've made a lot of changes in my social circle, and just as part of 7 years of maturation and just kind of where my life has taken me, there's just a lot that I'm not a part of anymore. And my focus is so highly focused on my family and my career those are some huge differences.
No further questions. Thank you, Dr. Spitzy.
I have no questions.
Good afternoon, Dr. Spitzy. I just have one quick question. You mentioned you are moving, or you've moved to the country, is that correct?
No, I think what you're referring to is my mother is moving out of the country.
Oh, okay.
Yeah.
So you are on baby number 2?
Yes.
Soon to be, congrats on
Yes,
that.
thank you.
And do you have a support if your mother is going to be, is no longer?
My mother and I haven't, we don't spend a lot of time together, so it's not, I wasn't getting support from her. My concern was more that I really wanted my children to be able to visit her, and so when I'm on the terms of this testing, I mean, well, I guess it's up to the board whether I'm able to leave the country for a period of time if I need to go visit my mother. So that was a concern.
Oh,
Yeah.
thank you for that clarification. No further questions.
All right, let me ask generally of board members, any questions for Dr. Spitzy at this time? I see no indication. Doctor, is there any additional information that has come to mind that you'd like to make sure the board members are aware of?
Not particularly. I guess there's one thing, being a new mother and being, full-time employed, I actually didn't really get to review what the Deputy Attorney General submitted until just like a night ago. And so I didn't even read, I wasn't able to read through all of it, but I did see some correspondence between, or something written about me in a meeting that I had with Mr. Gardner when I first met him, when he first became my probation monitor. And there was just a little narrative that to me didn't reflect the true, or both sides of the conversation that we had in our meeting. It was just saying something about how I was very opposed to the testing and very not okay with being a part of this. And I just wanted to clarify that meeting and my concern had nothing to do with the actual going and testing. It was more because when I first started, I had been provided testing sites that weren't even open anymore, that weren't the right phone numbers, addresses, and so I was having a lot of anxiety because I couldn't, it just worried me a lot that I wasn't going to be able to make it to a testing site, or when I got called into testing and I would call the site to try to go and they weren't open or they didn't exist anymore. That was the conversation. That's what I was frustrated about, not having to comply. So I just wanted to clarify that. I don't know if there's anything else at this time.
All right, thank you, Doctor. Mr. Bill, any further questions for Dr. Spitzy?
I just have one. Dr. Spitzy, you are once again you're planning on going on maternity leave again, correct?
Yes.
And I'll have a couple of questions. When do you plan on starting your maternity leave?
I'll probably start mid-July. My son was born at 37 weeks, so my due date is August 3rd. I'm probably going to take off a few weeks before. I had very fast labor. I didn't take any medications, and I am concerned if I'm at work and go into labor.
And how long do you anticipate being on maternity leave?
I'm hoping to take less time than I did last time, so maybe 2 months. But it kind of depends on how things go with the new baby. It's pretty hard in the beginning.
So right now your completion date is scheduled for December 7th, 2019?
That's correct,
Okay.
yes.
And if you go on maternity leave for 2 months, your completion date will be February 7th, 2020?
That sounds right.
Okay. Okay, nothing further.
All right. And let me ask generally if board members have any follow-up questions for Dr. Spitzy? I don't see any indication of further questions. All right, let's return to the subject then of Exhibit 14 for identification. Mr. Bill, were there specific objections that you wish to raise as to Exhibit 14?
I would just ask that the letter from the DCA be admitted as administrative hearsay, and then I would ask that the review article, I don't believe that's relevant. There's no foundation, so I would ask that the court remove that.
All right. As to foundation, I'm going to overrule based on the relaxed rules of evidence in administrative proceedings. Bear with me just for a moment. The letter from the Department of Consumer Affairs that you've referenced is a hearsay document. It'll be admitted with the limitations of administrative hearsay. And Mr. Bill, any more specific objection or comment that you'd like to make with respect to Exhibit 14?
No, Your Honor.
All right, so I will receive Exhibit 14 with the limitations as previously stated. Let me see if there's any closing argument either side wants to make. Let me explain, Dr. Spitzy, that technically there's a distinction between argument and testimony. Testimony is facts. Argument is what we should do with the facts we've heard. We'll hear if Mr. Bill has any closing argument, and then we'll see if there's any additional comments you'd like to make. Mr. Bill, any closing statement?
Yes, Your Honor.
Go ahead.
In this matter, once again, this board was not given the ability to grant the requested relief under 2962. That code section allows relief for a person whose license or registration has been revoked, suspended, surrendered, or who has been placed on probation. Dr. Spitzy's license meets none of those qualifications. This board specifically rejected the ALJ's proposed decision that granted the license, revoked it, and then placed her on probation. In that situation, if that proposed decision would have been adopted, Dr. Spitzy would be eligible for relief under 2962. However, the board rejected the decision and granted a conditional license with terms and conditions. And the analysis is contained in legal conclusions number 3 on AGO 0047. The order stated, the board will order the issuance of a conditional license with terms and conditions, the issuance of which does not require the denial of the license, as it is considered a licensing decision and not a disciplinary one. The intent of the board was to grant her a terms and conditions license, a conditional license, because that type of license requires the completion of all the terms and conditions prior to the vesting of the license. This was the intent of the board. And I would ask, once again, I would ask the board to reject the petition, not because of lack of effort on the part of Dr. Spitzy. It appears that she is in compliance with the terms and conditions. It appears that she is working hard towards gaining her unrestricted license. This board just simply was not given the power to grant this relief by the legislature. 2962 doesn't allow it. And for those reasons, I would ask that the board deny the request.
Thank you, Mr. Bill. All right, again, Dr. Spitzy, you're allowed to make a closing statement. You may proceed. You're not required to. And Mr. Bill, if there's any additional new factual information included in any closing statement, I'll give you the opportunity to inquire further. Dr. Spitzy, is there any concluding statement that you'd like to make to the board before we finish the hearing?
I think I'm just struggling with this because I struggle to, just with Deputy Attorney General Bryan's Bill's plea that I'm not allowed to apply for early termination. I just struggle with the understanding of it. My understanding when I signed this contract and the conversations I've had, and I wish I would have focused on this a little more, but that I would be eligible to apply. And just from what I heard in my correspondence with Governor Jerry Brown's office and whatnot, it's difficult for me to take in and process because I didn't have a license and then commit a crime and then get placed on probation. I understand that there's a difference, that what I had done had happened prior to application for licensure. So I guess I just hope that there's room somewhere in the law to base it on the merit of and what I presented today, rather than I have a hard time understanding it. I guess I don't have much more to say about that. I'm not a lawyer and I don't know how to defend that exactly.
Any other concluding comments you'd like to make to the board?
I just hope that you all are, able to look at what I presented and see that, I've gone through a lot to get to where I am today, and it's had a huge impact on me. So I guess regardless of what happens, I'll never forget this. So thank you guys for being here and listening to me.
Thank you, Dr. Spitzy. Mr. Bill, any need for further inquiry?
No, Your Honor.
Board have any questions or concerns before we close the record? No. All right, Dr. Spitzy, I thank you very much for being present and presenting to the board. Mr. Bill, also appreciate your presentation. At this point, we'll consider the matter as being under submission, and the board will entertain executive session on this. The record is now closed. We're off the record. Sure. Doctor, Mr. Bill, the court reporter has an information. It will take him a few minutes to fill out, but you'll have a copy for each of you. Thank you.
We're not going to adjourn, not adjourn for the day, but we're going to go into closed session for purposes of determining these matters and others. In light of that fact, we will be going back on the record briefly at the end of the day, simply to adjourn the meeting for the day. So there'll be no substantive business taken care of after closed session. Thank you very much. Board members.